In view of the aforesaid discussion, this court is of the opinion that the impugned decision to cancel the provincial election does not suffer from any legal infirmity, and accordingly, the petitions are held to be without any merit. Both the petitions accordingly stand dismissed. However, considering that the petitioner Prafulla Kumar Nath appears to have served for a long period of time, in case the authorities are of the view that the subject of history is required to be formally permitted in the school, the case of the petitioner may be considered in accordance with law. Yes.
Absolutely, Lordship. Lordship, I beg to mention item number 23, my lord.
Yes.
In this case, my lord, we are newly engaged, my lord. Yesterday, we have filed out Wakalatnama, my lord. For the petitioner, my lord.
Okay.
After 2 weeks, my lord.
Earlier set of councils are not there.
No, my lord. They have filed their NOC, my lord.
Your name?
A. Mubarak.
A. Mubarak. A. Mubarak Learned Council has submitted that he has entered appearance on behalf of the petitioner recently and praised for some time. Para, at least after a week.
Up to 2 weeks, my lord.
At least after 2 weeks. Para, raised it to reflect the name of Sri A. Mubarak and the new set of council.
They say, interim is there, my lord.
Para, interim order passed earlier, but to transaction.
Pass it.
We fix a date, and if the
Lot-
interim order, we fix it
Lot-
at least on 14th of August.
I beg to mention, MSC appeal number 592/22, my lord. There is some urgency in the matter. We are the respondents, my lord. The awarded amount was not released till,
Not released.
not released.
50%.
No, not paid.
21.
Or fourth,
Fourth is Friday.
my lord.
Friday.
Or maybe on seventh,
Or have it on 7th.
seventh. my lord.
May it please your lordship. Your lordship, I beg to mention item number 48 of today's list, your lordship. In this case, your lordship, counsel representing the case, Mr. P. Sundi, his name is not reflected, your lordship. And the case has come up for compromise settlement, your lord.
Sundi is for the respondent.
Yes, your lordship. Respondent claimants, your lordship.
Claimant, okay.
My prayer is that the matter may be
And-
listed next week, your lordship, any day.
Your name is not there, madam? Oh, yes, Bothakur.
Yes, your lordship, P. Bottom.
I'm a P. Bothakur. Learned Council for the applicant appellant submit that though the claimants
Claimants.
have entered appearance through Learned Council Sri P. Sundi, his name has not been reflected in the court. Para, please, in the next week, by reflecting the name of Sri P. Sundi, Learned Council for the respondent claimant.
Obliged.
48. no?
May I please-
দুইটা থেকে এটাই order. Wonderful. Yes,
May I please, your lordship. I beg to mention item number 41, your lordship.
yes,
My senior is not well. He is having severe eye infection, your lordship.
okay.
So unable to proceed,
Your senior is NN Upadhyaya.
lordship.
It is submitted that Sri NN Upadhyaya is not well. Have you taken the consent?
I will inform your lordship.
Have you?
Yes, I will inform you.
Will is a different, we are not concerned with will.
I tried to communicate, but
Trying is also not enough. Don't make a mention. We have made it enough, clear enough. If you make a mention without consent, we'll impose cost straight away. Takes 4 years to go into the bar that this court is not going to allow, or not this court. No court is going to allow mention without consent.
senior is having problem, that's why.
We will adjourn it, but not now. You are supposed to inform them. Yes, no, let the matter reach.
Hey, please, my lords. The beg to mention item number 9, my lords. It's a
9.
bench matter. I'm praying for a short accommodation, my lord. I appear for the petitioner. This matter can be taken up on Friday. subject
Item
to my
9,
lordship. Item 9, my lord. Oh, shit.
your name,
Each of them. My lord, it's not reflected. I've been engaged in the matter, my lord.
you are for the petitioner.
Petitioner.
Sri B. Chaudhary, Learned Council, submit that he has been recently engaged in this matter and accordingly praised for some time. Next week,
Monday, then
List on Wednesday next date, huh?
briefly obliged.
May it please your lordship, one old pending second able to be listed for orders. We came to know that one of the applicant died, so need to do the needful lordship. As per your lordship convenience,
Monday.
much obliged.
Have you filed IA for substitution?
Not yet lordship. Because most probably there are legal errors in the record, so
Okay, Monday.
May it please your lordship, madam, with the consent of the other side, I beg to mention item number 39,
39, yeah.
40 of the daily list, my lord.
Hmm.
The conducting counsel of for the appellant, Mr. R. Bob Pujari is not well, my lord.
Okay.
Pray for adjournment, my lord.
Other side has the
Yes,
separate
Can it be on 22nd of August? or
22nd. Madam, 22nd,
Yes, my lord.
it is submitted as pre-R purportary. Senate Council conducting this case is not well put up. As agreed to by the parties, list on 22nd, 22nd August.
Obliged.
Deeply obliged.
Yes.
Please, your lordship, I beg to mention an FAO matter for listing, your lordship.
Fresh matter.
Yes, sir.
When did you file?
It was filed on 20th of July.
Does not come as yet.
No.
21.
Lordship, if your lordship permits on Friday. Obliged.
May it please your lordship, listing of the CRPIO lordship. It was filed,
Fresh matter.
no lordship. It should
And
come
the
up on
pending matter,
orders,
pending
yes,
matter.
lord.
Okay, next Wednesday.
Obliged, lordship.
May I please your lordship, I beg to mention item number 45 for upgradation lordship.
45.
Lordship, it may be taken up at 2 or any time before lordship rises. Sir. Lordship, the matter is fixed before the arbitrator tomorrow. It is without our consent.
We cannot upgrade. We will try. But we're not assured.
Highly obliged, lordship.
May I please your lordship? Your lordship, I beg to mention RFA 59 of 2017. As in this RFA, the surface action of the bank is under challenge, and the matter has been under the part 2 list also. But your lordship, I beg to pray for listing because since
17 matter.
surface
17 matter.
17.
21.
Hello.
21.
Your lordship may come up on 22nd or 25th. 24th.
22nd of August.
Yes, sir. Hello.
May it please your lordship. Lordship, I beg to mention a civil revision petition for admission, lordship. Lordship, the said case is fixed before the London Civil Court in Norbury on 4th, it's on Friday. Lordship, kindly take up the matter for admission, lordship.
When?
Wednesday, lordship.
Wednesday is today is Wednesday.
No, next Wednesday, lordship, 9th.
This matter is fixed on the Friday thereafter,
Yes.
on 11th.
On this week, 4th.
And if it is already fixed, why do you want? Okay, we'll have it on 9th. Matter of which year?
Lordship,
Matter of which year?
2022, lordship.
I have it on 11th of August, 11th.
Obliged.
May I pray for upgradation of the matter? I think 47. It has 46. It has not raised for 2 times since the last occasion. At 2 looks.
Difficult upgradation.
I have an interim prayer. That is well.
So there are some of the list matters.
If possible, at 2 o'clock or
We'll try, but we cannot assure. Upgradation is not difficult. Parents on matters. There are some of the list matters. We finish those first. Motions are there. Let us see. We'll try.
looks.
may I please lordship, I beg to mention for listing lordship, next Friday lordship, civil revision matter lordship,
What is the stage?
stays motion lordship.
Motion matter.
Yes.
Motion we can have it day after tomorrow.
Therefore,
Fresh matter.
press matter, before it was listed lordship,
But notice of motion has not been
no
issued.
lordship,
Either Friday or Monday, whatever you wish.
Friday lordship, much obliged.
You're for the public works department.
Yes, lordship,
This is an old matter.
very old matter, today I have seen.
take up for disposal.
Lordship, approval, because it's 2013 matter. So it's very old.
You are equipped with the instructions. You have the
Lordship,
instructions.
I am not instructed, but already it's old matter, therefore.
No, no, we'll definitely give preference, but are you prepared with the matter or not?
Actually, I am not prepared because today I'm going to.
No, no, last time there was none from PWD. We had called the
Yes,
matter on
yes.
2 occasions.
Name-
Mr. Sharma was there.
Yes,
Names
Lordship.
are not properly shown, and one officer who was party by name, his name has been struck off.
Yes.
So only
Lordship.
PWD remains.
Yes, I have seen the order.
Now, we can have it day after tomorrow or tomorrow,
Yes, Lordship. Next week, any day, I will take instruction.
because we, 13 matter definitely we are not adjourning, but we'll accommodate you for a short time.
Lordship.
Get the instructions, so that at least you can,
Yes, Lordship.
because this is the first debate.
Yes.
My lord, it may be taken on 11th, my lord.
And it's a limit, it's a very on a limited point.
Yes.
The relief
limited
has been
point,
partly
yes.
granted
Only-
only.
Yes, yes, Lordship. Claim interest and all.
Yes, yes. Yes.
Yes.
He
Maybe
is claiming the
There
claim
is-
is based on delayed payment. And there is a escalation clause, I think.
Yes, yes. And then storage of bitumen that was not released.
my lord,
I'll take it.
if it is not taken today, then it may be taken on 11th, my lord.
Not 11. Have we done 10th?
10,
10th, we'll be able to complete it.
10, okay.
Because 11th will be a motion day, we don't want to,
Yes.
till 10.
10 at 2, at 2 p.m.
Why?
No,
Morning?
some motion
No,
admission.
no, 10th is a Thursday.
Oh.
Thursday we can have it in the morning. Third pre-case. Concept for the appellant. Para. This court by its last order dated 27/7/2023 had directed reflecting of name of pending concept PWD in the cause list. And today, S. Sharma, learned counsel for the department has appeared and has submitted that some accommodation be granted as she is not equipped with the instructions. In the interest of justice, not considering that this matter is an old one, and in the interest of justice, this matter is directed to be posted again on 10th of August, on which date the same will be taken up for disposal. The complement. The LCR is also there.
Yes, Lord.
If you want to have a look, you can have a look.
May I please? Your
Yes,
Lordship? My lord, this is a matter of provincialization, my lord.
Yes.
The petitioner had been provincialized as a tutor principal. My lord. My lord, on the strength of the said
So last
provincialization.
year, having the instructions.
Yes, ma'am.
Affidavit
I
is not
filed
filed.
affidavit.
Lordship, they have filed the affidavit, Lordship. I am
Okay.
appearing item number 5. So I need some time to file my reply to this case.
When was the affidavit filed?
Yesterday, Lordship.
Yesterday. And in your case,
My lord, it is filed in my case, my lord. I don't think he should have any grievance with the.
No,
my
no,
lord,
I
this-
mean item number 5 in my
Five,
case.
my
I
lord.
insist.
now that part we cannot object. He has the right to file a return.
That is correct, my lord, but
His case.
Anyway, both the cases are connected, my lord.
See, these are matters assigned to this bench.
my lord.
We'll grant you time, but very short time.
Lordship, a week's time, Lordship.
Week's time.
Lordship.
What is the matter?
My lord, my provincialization, my lord, has been as a.
You were similarly placed.
No, my lord, no, my lord.
No.
My lord, they are against me that the charge, my lord, which had been conferred to me to manage the affairs of the principal of the college, my lord. They are agreed with that order, my lord. That had been put into challenge
By them.
by them, my lord, and that there is an order of this honorable court, my lord, interfering with the said order, my lord. Accordingly, my lord, what the department has done, department has as a whole, my provincialization has been kept in abeyance, my lord. irrespective of the charge they have taken away from me, as well as my provincial.
Why is this writ petition still pending then?
My lord, he is one of the writ petition is pending, my lord.
No,
But the,
if you say
my lord,
that your, the arrangement of
My-
giving charge to you
my lord,
was successfully challenged by them,
yes, my lord.
thereafter, not only the charge, the entire provincial has been kept in abeyance.
Enter province.
You are aggrieved by that.
We are only agreed by that, and they,
You are not contesting on the charge.
no, I am not contesting with the charge, my lord, and he is contesting with the charge, my lord. And my
Charge
lord,
has
he-
already been given.
he has got his relief, my lord.
Lord, the charge has been given to the inspector of the Boko College principal. That is lordship in the order, lordship, which says that he has been temporarily allowed to hold the charge of the principal. But
Who?
that is the principal of the Boko College. That is only an interim arrangement.
My lord, what has happened, my lord, by taking.
We'll make that arrangement absolute and we'll hear his demands,
My grievance is very limited, my lord.
because he's only aggrieved by, he's keeping in abeyance the provincial election order.
Because, my lord, my salary, everything has been blocked, my lord.
Mr. Chakraborty, see, your grievance is substantially has been redressed.
My lord.
If you have any apprehension regarding the nature of the interim order, we'll make it absolute.
Exactly, my lord.
No, lordship,
He is also,
I mean,
he is also claiming the post of principal
Lordship,
of that
I'm praying for
college.
a direction for appointment as the in-charge principal. To that extent, lordship.
Oh, that part is still remaining.
Because, my lord, in the meantime, what has
In
happened, my
that
lord?
case, I think his case can be segregated.
His case can be segregated, my lord. My lord, what has happened, my lord, in the meantime,
If you are admitting that you are not very much interested in the charge,
my lord,
you are only interested in your service being provincial.
provincialized as a, my lord,
We can
tutor,
adjudicate your grievance.
my lord.
Well, there is something actually, his service has been provincialized as a tutor principal, my lord. Now, if my lord, he's
Principal is,
restated, my lord, he'll has to be principal or
Oh.
charge principal, my lord.
Okay. Okay, we'll have it after, we'll fix the date.
My lord.
If I file your return. Third. Three. AR Bhaiya. Senate Council for the petition in WPC 3723/2022. Whereas 3A Chakraborty has appeared for the petitioner in WPC 6427/2021. Full stop. The matters appear to be connected, in which the department has filed their affidavit. Full stop. Correct. Sri Chakraborty, the learned counsel, however, submits that the affidavit of the department in his case was filed only yesterday, and he accordingly placed some time to file a rejoinder affidavit. Full stop. Correct. To fix the date, since these matters are specially assigned to this bench, let these cases be listed. Let this case, not let, these cases can adjourn by a week to enable filing of rejoinder affidavit and be listed on.
Lord, after 10th, my lord, I have some personal,
Okay, we'll have it on 14.
my lord, my lord.
14.
Oblige that.
At our-
Obliged.
Yes.
In this case, she has appointed as per advertisement of 2023, probably that is why they are not appearing.
They have been,
She has been appointed, she has accordingly joined, in the post of assistant teacher, That is why, petitioner is not representing.
none appears for the petitioner on call.
Last occasion, there is.
Whereas Sri P.K. Bora, current standing council, elementary education is present. Full stop. Even on the last occasion, there was no representation on behalf of the petitioner. Even on the last occasion, the first line of the collector. P.K. Bora next, P.K. Bora No, but not done a peaceful petition and call even in the last occasion. After PK Bora, Leonard Standing Council, Elementary Education Department was granted time on the last occasion to obtain instructions. Compare. Sri Bora, the Leonard Standing Council has submitted that he has received written instructions from which it appears that the petitioner has been appointed as
Assistant teacher, madam.
assistant teacher. Also, Sarah, period does it make, comma, in absence? Period is the He further submits that it is perhaps because of this reason that the petitioner is not present. Be that as it may, comma, instead of entering into the marriage in absence of the parties, comma, this petition is closed for non-prosecution. The written instructions dated 1/8/2023 received by the Learned Standing Council is made part of the record.
Madam. Obliged.
Please, Lordship. The matter pertains to provincial election, Lordship.
Hmm.
Her name was dropped from the provincial election list. And Secondary Education has filed affidavit, Lordship. And in their affidavit, they said that sufficient students enrollment was not there during 2016. But as per our annexure, Lordship,
Hmm.
annexure 10, page 50.
50.
50.
Yes.
So due to some less enrollment,
Yes.
their service has been provincialized, Lordship. Sufficient enrollment should be 10, at least 10 students.
Hmm.
Here, Lordship, Moitamingam Kodam Senior Secondary School, History 8, Posim Junai Senior Secondary School, Math 7, and Ratnatip Senior Secondary School, History 8. All
Hmm.
these teachers' services are provincialized, Lordship.
If
Despite-
some irregularity or illegality has been done, you cannot claim the same benefit. You can rather challenge him, but yes, what is this?
Their contents,
They have not fulfilled the criteria of the provincialization act 2017. Here,
No,
my
he's-
lord, as per provincialization.
He's trying to bring in an analogy from page 50.
Yes.
He has cited 3 examples from this information received under RTI Act,
RTA, Lordship.
out of which there are 3 persons whose services have been provincialized, in which the enrollment is less than 10. Correct, Mr. Neo?
Yes, Lordship.
50. But this by itself will not give you an indiscussible right. Article 14 is a positive concept.
So matter may be, my lord, remand back to the director so that they examine the matter or verify the matter after their answer.
So if he has not fulfilled the criteria, how can such direction be given?
Similar petition has been disposed of, Lordship, and directing the director to take a hearing, Lordship. After
You know,
taking-
first you have to satisfy the court that you have, in spite of fulfilling the requirement, you have not been given the benefit of provincialization.
If these 3 persons are, lots of examples are there, Lordship.
See, somebody being given some undue benefit, you cannot claim an undue benefit. After all, this is a court of law. If they on their own volition, they give you the benefit, we have nothing, no objection. But we cannot direct them.
Yes, Lordship. But this matter may be disposed of directing the respondents pass any appropriate order after
Mr.
taking a hearing.
Sharma,
This, my lord, direction may be
we will
given.
not recognize his right, but we'll give liberty to file a representation. He can cite the examples, then if
Lordship.
part three, continue,
Lordship.
then it counts it for the petitioner. Also heard Sri U Sharma, Understanding Conflict, Higher Education Department,
Secondary Education Department.
Secondary Education Department. Sri Sharma, no, Secondary Education Department, who submit that affidavit in opposition has been filed on 28/6/2023. Full stop. The issue raised in this petition is with regard to provincialization of the service of the petitioner who is serving as a postgraduate teacher in the subject of history in the Gogamukh Senior Secondary School in the district of Dhemaj. Full stop. Para. It is the projected case of the petitioner that he was appointed in the aforesaid post on 18/8/1997 and has been working continuously. Full stop. However, in the exercise undertaken for provincialization of service under the 2011 Act,
2017 Act, Lordship.
2017 Act, Act of Elective. What is the name of the act?
Assam Education within bracket provincialization of services of teachers and reorganization of educational institutions within bracket Act 2017, bracket close, Act 2017.
You have to set it up. Para. The Niyog the Learned Council has submitted that the petitioner has obtained information that the denial of provincialization is mainly on account of not meeting the minimum enrollment in the particular subject, which has to be 10. Full stop.
The department has also filed the affidavit there, in paragraph 6, they have taken that contention that due to less enrollment, my service was not provided.
The Learned Council, however, submits that there are instances where even in case of enrollment being less than the prescribed numbers, certain incumbents have been given the benefit of such provincialization. Full stop. Para. In this connection, Sri Nehru has drawn the attention of this court to page
50, Lordship, Annexure 10.
to page 50
50.
to a reply dated 22/9/2022 received under the Right to Information Act, whereby it has been informed that out of 6 numbers of incumbents named therein, so far as 3 incumbents are concerned, the number of students is less than 10. Full stop. He accordingly submits that a direction be issued for consideration of the case of the petition. Full stop. Para. Per contra, Sri Sharma, the Standing Council of the department, has submitted that the directions are for is not supported by the statute holding the field. Full stop. By drawing the attention of the court to the affidavit in opposition filed by the respondent number two, dash Director of Secondary Education, Assam, on 28/6/2023, comma, he submits that a specific stand has been taken by the department on the point of number of students who are enrolled in the particular subject. The learned standing council refers to the pleadings made in paragraph 6 of the state affidavit in opposition, which reads as follows, page 57, paragraph 6. Sarah. Sri Sharma, according to submit that the petition is misconceived and is liable to be dismissed. He further submits that merely by citing citing certain examples, certain instances of incumbents being given the benefit of provincialization despite not meeting the enrollment criteria, comma, the same would not justify issuing a direction as the right guaranteed under Article 14 of the Constitution of India is a positive right. Put the para. Three. To know the learned council for the petitioner, however, submit that the matter may be directed to be considered by the Director of Secondary Education or any other authorities on a secondary education. Put the para. The stand taken by the department in paragraph 6 is a categorical one, wherein it has been stated that the number of students in the subject of history in the year 2016 was fixed,
At least
whereas under section 3 within bracket
1/7.
1 within bracket Roman 7 of the Act stipulates that there should be at least 10 students. Put up. The aforesaid averment made in paragraph 6 of the affidavit in opposition have not been controverted or denied by the petition by filing any rejoinder affidavit. And therefore, the said step appears to be an uncontroverted one. Put the para. So far as the instance cited by the petitioner that certain incumbents have been given the benefit of provincialization in spite of less enrollment, comma, this court finds force in the contention of Sri Sharma, the Learned Standing Council, that Article 14 of the Constitution of India is a positive concept, and only because certain action is irregular, comma, the petitioner cannot seek a similar action, seek a direction for a similar treatment. Para. In view of the aforesaid facts and circumstances, comma, this court is of the opinion that no legally enforceable right has been thought to be has been able to be established by the petitioner in this case, and accordingly, the petition is dismissed. The petitioner, however, is at liberty to submit necessary application before the authorities, which may be considered considered by this considered strictly in accordance with law, and by taking note of the present enrollment, note of the criteria laid down for such provincialization.
Yes, Lordship.
Yeah, please. Yes, of course.
So here the order dated 1/6/2023 passed in Mise case 389/19 by the learned court of motion number 1 is put under silence. The Mise case was filed under order 21 rule 32, my lord.
Just a minute. Yes, tell us, Mr.
My
Board.
lord, the impugn order lordship will find at page number
You
130.
are the plaintiff.
No, I am the I am the defendant. My father was defendant. Our father was the original defendant. He died.
How many petitioners are there? Two petitioners.
Both are sons of the original defendant.
Hmm.
We are the
Sons
successor
of-
of the original defendant.
Original defendant.
Yes, Madhav
Yes.
Medi.
Suit instituted by whom?
By our aunt, the present respondent,
Hiran Madhi.
Hiran Medi.
She is your aunt.
Aunt, our aunt, paternal aunt. Suit was instituted in the year 1998, my lord. That was title suit number 168/1998.
168.
8/1998.
Okay.
And in the suit, our grandmother was the pro forma defendant. The case of the respondent is that our grandmother executed one gift deed in favor of the plaintiff. And on the force of that gift deed, she has filed this suit for declaration of her right title and interest over the land mentioned in Schedule A and B. Thereafter for recovery of possession, also for confirmation of possession and permanent injunction, my lord. And the suit was initially decreed by judgment and decree dated 4/12/2003.
Okay.
My lord, thereafter an appeal was preferred by our predecessor.
Your father.
Yeah, our father. And in that appeal, my lord, the matter was remanded to the learned trial court with a direction to frame two issues.
Demanded by appellate court.
Yes, by the appellate court.
Yes.
One of the issue was whether the possession was delivered to the plaintiff or not. And the second issue was whether the plaintiff was dispossessed from the suitland or not.
No, since there was a prayer for recovery,
Yes,
what was the name requirement of such an issue?
my lord.
It was already their case, they are praying for recovery.
But the aspect of disposition,
Doesn't matter whether they are dispossessed or not, they are basing their claims on the basis of a gift deed.
give it, my lord.
Now, gift deed is not the part of challenge.
No. What happened? Our predecessor also filed a counterclaim,
There
and
was a
that counterclaim was also dismissed.
counterclaim challenging the gift deed.
Yes.
Now, did you file a appeal against the counterclaim dismissal?
No. That
Then-
was not done by our predecessor. My lord,
Then the validity of the gift deed has attained finality.
yes, it is there, my lord.
Now, these two issues, do you think that will be relevant?
Yes, my lord.
Why?
Why, my lord?
If
Then-
the prayer was not there for recovery of possession, Whether they are dispossessed or not, that will hardly matter. They want recovery of possession means they are not in possession. They want to decree that the possession should be recovered back to them.
Then, my lord, finally,
Now, what is your case now?
my case is that, my lord,
On these two issues, it was remanded back. Thereafter,
he has remanded. Thereafter, again, on those two issues, evidence was taken. And the issue of disposition was decided against the respondent.
what were the two issues? Whether dispossessed and number two?
Whether possession was delivered, that was in affirmative. And whether she was dispossessed, it was decided in the negative. And against that, no appeal was preferred by the respondent.
It was held that possession was indeed delivered to them.
He delivered to her. But regarding the aspect of disposition, my lord, it is discussed,
Not dispossessed.
it
They were
was
not-
decided in negative.
That means not
As
dispossessed.
because she was pleaded, but there is no material on her evidence.
That means it was held that she was not dispossessed.
Yes, it was decided in the negative.
Okay, thereafter,
Thereafter, my lord, High Judgment and Decree dated 2/6/2006, the suit was again decreed. And that was the decree for the declaration of plaintiff's right, title, and interest over the entire land mentioned in Schedule A and Schedule B. Number two, decree for permanent injunction, full stop, and cause of the suit. Now, my lord, the plain may be seen.
now what is your difficulty now?
My lord, what happened here? This was decreed in the year 2006.
Correct?
Against this decree also an appeal was preferred
By you.
by our predecessor, which was dismissed in the year 2008 in the month of May, in the month of March.
Appeal by your father.
Yes, by my father. That is title appeal number 75 of 2006. And it was dismissed by judgment dated 31/3/2008.
31?
3/2008.
Okay.
Now, thereafter what happened? From 2006 to 2019, the plaintiff was just sitting over the decree, doing nothing. She didn't put the decree for execution.
Okay.
So, Order 21, Rule 10, my lord, it says that after execution, after judgment, there must be an application for execution. And there is a format, the form number 6, Appendix E of the CPC. A tabular form is there, by which generally the decree holder file an execution case. And this decree dated 2/6/2006 was never put for execution. And long after 13 years, the respondent has come up for the execution of the decree for permanent injunction. Although nothing is elaborated, what sort of permanent injunction is granted. And thereafter, my lord, page 104, Annexure 9, this is the application filed by the respondent under Order 21, Rule 32. 104, my lord.
Okay.
Only the Schedule B.
Application for?
An application under Order 21, Rule 32, read with Section 151 of the CPC. Dear Lordship, the prayer portion is, my lord, at page number 130.
113.
113, my lord.
Yeah. Yes.
It is therefore prayed that Your Honor would be graciously pleased to admit the application. Issue notice to the opposite party's judgment debtors to so cause as to why the possession of the decretal property described in Schedule B to the plaintiff as well as the present application shall not be restored in favor of the petitioner by demolishing the unauthorized construction made by the opposite party's judgment debtors thereon, and after hearing both the parties, Your Honor would be graciously pleased to restore the possession of the said decretal property, particularly the property described in Schedule B, as described in the plain as well as in this application in favor of the petitioner, by demolishing the unauthorized construction, and further be pleased to punish the opposite party's judgment debtors for violation of the decree for perpetual injunction as provided under Order 21 Rule 32 Code of Civil Procedure, and to award compensation in favor of the petitioner and pass such necessary orders as Your Honor may deem fit and proper for the ends of justice and fair play. And in regard to this application filed under Order 21 Rule 32, we have also filed our written objection. That is Lordship at page number 116.
116.
116. This is our written objection, my lord. And after hearing both the sides, although some disputed question of facts were raised by the decree holder, but no evidence was given. And thereafter, by order dated 1623, page 137, it starts from 137, my lord, up to page number 152. Operative part, my lord, at page number 152.
One five two,
152, my lord. Internal page number 16 of the order.
yes,
Under said circumstances, the prayer of the petitioner is allowed under Order 21 Rule 32 read with Section 151, whereby the defendant opposite party is strictly directed to demolish any unauthorized construction carried out over land mentioned in Schedule A or Schedule B of the plain, and as per the gift deed within 2 months from today. In default, the civil nazir is directed to demolish any unauthorized carried out over Schedule A or B land by the opposite parties and restore the possession of Schedule A and B land in favor of the petitioner. The opposite parties are also restrained from disturbing the peaceful possession of the Schedule A and B land by the decree holder petitioner. The DH is at liberty to take steps in ease of default after expiry of 2 months from today.
in case of default.
In case of default, my lord, after expiry of 2 months from today, and the means case is disposed of. So we are agreed upon this part of the order, my lord, as because the settled position of law is that executing court cannot go beyond the decree, my lord. Here, my lord may be pleased to see what sort of prayer was made in the original plain. And the aspect of disposition is also pleaded in para 7 and para 8 of the plaint. And that lordship will find at page number 34, our neatly typed copy.
Thirty-four.
34, my lord.
Yes,
Para 7, my lord.
starts at 30,
34.
starts at 29, this is the plain. 29 the plain. start.
From 29 it starts, annexure 1. So
You want to show 34.
page number 34, para 7, my lord.
Yes.
That the plaintiff has been paying land revenue regularly through her cousin brother, as he is the person who has been all the time with the pro forma defendant since the plaintiff got married. Now the defendant denies the ownership of the plaintiff over the land Schedule B and tries to encroach her property by constructing a brick wall around the boundary of the land of the plaintiff along with her mother and cousin brother. Para 8, that the defendant has already enclosed a major portion of the disputed land mentioned in with Schedule C with construction, which he refuses to remove from there, causing hardship to the plaintiff. The village people also tried to solve the problem as per the rules of village taluk, and the defendant had promised not to disturb his mother and her property, but the defendant later on could not keep his promise and he started harassment to his mother, and the plaintiff finding no way out, the plaintiff was compelled to file civil suit for declaration of her title over the disputed land in Schedule B. The plaintiff came to know about striking out her name without her knowledge only few months back, my lord. Thereafter, the prayer portion, lordship will find from page number 36. At the bottom, my lord. 1. Declaration of right title and interest of the plaintiff over the entire land mentioned in Schedule A and Schedule B. 2. Recovery of possession of disputed land total of 1 kotha 3 lesa and portion of land mentioned in Schedule B, the boundary of which are north Gangadas, south Chandradhar Das, east Government Road, west Madhav Medi, from the defendant after a proper measurement. So this part is important. After a proper measurement, the confirmation of possession of the disputed land in Schedule B in favor of the plaintiff, and for a permanent injunction restraining the defendant from any
Now,
construction over the
don't you
disputed
think-
land.
Don't you think 2 and 3 are in conflict? They are praying for recovery of position
Yes,
of Schedule B as well as confirmation of position.
yes.
These are conflicting, aren't they?
No, my lord, her case is there. Lordship, the Schedule B is mentioned at page number 38.
No, even prayer 2 and prayer 3, both are pertaining to Schedule B only.
Yeah.
If they are praying for recovery,
Yes.
how can they pray for confirmation?
No, in one part, it means that in one part she has possession. That is 13 lesser. Lordship, in Schedule A, there are 3 plot of land covered by 3 separate dag and patta. And Schedule B is one of those dag and patta. That is the land measuring total 1 kotha 16 lesser covered by dag number 444, patta number 118, village Mirzapur, Moza Ramsarani. This is a part of land mentioned in Schedule A here and in the Schedule of the gift deed dated so and so. Thereafter, Schedule C may be seen, my lord. Here it is said recovery of possession of 1 kotha 3 lesa
Out of
1 kotha 16 lesa
of B.
of B. Out of 1 kotha 16 lesa mentioned in Schedule B from the defendant who newly had taken the portions boundary of which the defendant built his house, and confirmation of the possession of land mentioned in Schedule A and Schedule B, and also 13 lessons of dag number 444.
Schedule
patta
C
number
is a
118.
part of Schedule B.
My lord?
Schedule C is a part of Schedule B.
No, my lord.
Schedule C land is a part of Schedule B land.
Yes, it is bifurcated.
No, B
The
is
Schedule B land is bifurcated in 2 parts. One is 1 kotha 3 lesser and
Understood.
another one is 13 lesser.
C is a part of B.
Yes,
And so for C is concerned, they want recovery of position,
position of 1 kotha 3 lesser.
which is C,
Yes,
and remaining part in B, they want their confirmation. of-
confirmation of position. But regarding, my lord, this recovery of position prayer, that is the prayer number 2 at page 37. It is said from the defendant after a proper measurement. And now the permanent injunction prayer here may be seen, my lord, at page number 37.
Yes.
For a permanent injunction restraining the defendant from any construction over the disputed land and not to disturb the peaceful possession of the land by the plaintiff.
Hmm.
Now, this is the permanent injunction prayer, my lord.
Hmm.
And in the initial judgment, my lord, that lordship will find at page number 72. The initial judgment of the year of 2003.
Yes.
The suit is decreed on contest with cost. The plaintiff is entitled to a degree of right title, interest, and possession as per the gift deed exhibit 1. Counterclaim is dismissed. So initially also, there was no decree for recovery of possession or for confirmation of possession or for permanent injunction, my lord. Thereafter, the second decree may be seen, my lord. Second decree, lordship will find at page number 90.
Now, there is in the initial decree, there is a decree for possession,
No, declaration of right, title, interest and possession.
declaration of possession.
No, my lord. What is said in that decree?
Yes. Suit is decreed on contest.
Suit is decreed on contest. It is ordered and decreed that the suit is decreed on contest with cause. The plaintiff is entitled to a decree of right, title and possession as per the gift deed. So what sort of possession, where nothing is discussed here. Thereafter, my lord, the second one.
What is your interpretation? So far as the first decree is concerned, there is no decree for what?
The initial one, my lord. My lord,
Which you have just read.
as per my interpretation, my lord, the decree is to a certain extent is vague. As because the cedil is also given here. In the plain also, there are 3 cedils given. Cedil A, cedil B, and cedil C, which I have already read. But upon which plot of land, nothing is said here. And this part is right now at this stage, my lord, I think is not material as because
Appellate court has already
remanded the matter. And now
Let us
this
come to the
second decree,
Second decree,
my lord, that is that lordship will find at page number 90,
90.
90, my lord.
Decree on remand.
After remand, my lord. 90, my lord.
Yes.
It is ordered and decreed that the suit is partly decreed on contest, partly, my lord, on the following terms. Number 1, decree for the declaration of plaintiffs' right, title, and interest over the entire land mentioned in cedil A and cedil B. Thereafter, decree for permanent injunction, full stop, cause of the suit, full stop. Now, my lord, as it is a decree for permanent injunction, full stop, nothing is elaborated. What sort of permanent injunction is granted? And thereafter, there is also no decree granted for recovery of possession or for confirmation of possession. But in spite of that, the respondent didn't file any appeal. Our predecessor filed an appeal. That was dismissed. But the respondent also didn't file any appeal. Now, what the learned trial court did, executing court did, in the name of interpretation of this permanent injunction decree, so gone beyond the decree which was passed, because now for the purpose of interpretation also, what is stated in the plain, what has been stated in the evidence, that has to be looked into, my lord. So in the original, in the plain, my lord, what the permanent injunction decree says, for a permanent injunction restraining the defendant from any construction over the disputed land, and second part is not to disturb. But now by filing this order 21 rule 32 application, what is prayed, my lord? At page 113, to show cause as to why the possession of the decretal property described in cedil B to the plain as well as the present application shall not be restored in favor of the petitioner by demolishing the unauthorized construction. My lord, here in the plain, there was no prayer for eviction.
This has been filed under order 21 rule.
32, my lord.
So far as it relates to an injunction.
My lord.
So far as it relates to an injunction.
Only for injunction purpose. My lord, what order 21 rule 32 says, it is related to for decree for specific performance for restitution of conjugal rights or for an injunction. Now, number 1, where the party against whom a decree for the specific performance of a contract or for restitution of conjugal rights or for an injunction has been passed has had an opportunity of obeying the decree and has willfully failed to obey it, The decree may be enforced in the case of a decree for restitution of conjugal rights by the attachment of his property, or in the case of a decree for the specific performance of a contract, or for an injunction by his detention in the civil prison, or by the attachment of his property, or by both. This is the mode prescribed under Order 21, Rule 32. So up to this extent, court can exercise its jurisdiction. But here in the present case, the learned court exceeded its jurisdiction, my lord. Because in addition, for the direction for demolition and for restoration of possession, my lord, the basic point is, when there is no decree for recovery of possession, how the possession will be now restored? First, there must be recovery of possession. Only then restoration of possession can be done, my lord. By giving this direction for restoration of possession and for demolition, my lord, moreover, my lord, in the plaint also, there was no decree sought for our eviction. Permanent injunction is only to the extent of not to construct anything and thereafter not to disturb the peaceful possession. That is where learned court, the executing court, goes beyond the terms of the decree. Now, in the name of interpretation, a new decree cannot be drawn up. That is the subtle position of law, my lord. And in the present case, it is done by the learned executing court.
Lordship, so far our application is concerned, that is under Order 21, Rule 32. An application under Order 21, Rule 32, read section 151 of the CPC. Because to that effect, I am coming to that. In the application, we have stated, after the decree being passed, after dismissal of the appeal, they have not gone. So they have started construction over the civil pillar, decretal property, because the learned trial court held that the, as per the gift deed, possession was delivered, gift deed is valid. So they have challenged in the counterclaim, that was dismissed. So gift deed is valid. Now, court in a subsequent issue, which are after remand being made, it was decided that dispossession was not made. So far, we have a list. That means we are in possession. Now, in their written statement, they have said they have denied our dispossession. That means we are in possession. Now, in the application, we have stated, after the decree being passed, the subsequent decree, they have dispossessed us from the civil villain. Now, what is their reply against the objection? I am coming to their reply, particularly in paragraph number.
But Mr. Bhuya,
Lordship.
ultimately, we have to, this issue will boil down to page 90.
Lordship,
Page 90 of the.
regarding permanent injunction.
Regarding the three decree, three
Lordship,
parts of the decree.
Lordship, 3
First
points.
is
Declaration of right title and
declaration
interest.
of right title and interest. There is no question of recovery or confirmation.
No, at that time, no recovery of possession required.
Then decree of permanent injunction and decree on the cost.
Lordship,
Now, he has shown Order 21, Rule 32, that the mode of, even assuming
Lord.
that you have a valid decree of injunction,
Lord.
which you have put to execution,
Lordship,
the mode of executing is prescribed in 2132.
Lordship,
Now, the direction which appears to have been given by the
Lordship.
executing court is beyond which is prescribed in
Could
Order
that affect
21.
could that affect your Lordship, our High Court decision is there.
Let us see-
Lordship, I am coming to that.
let us-
Lordship, in their reply, what they have
let
stated,
us see the decision.
that is,
Let
What?
us not go into the.
they have stated in paragraph number,
Let's start the decision.
Lordship. That is 2002 GLT 121,
2000.
2002 GLT 121.
Name,
Lordship,
name.
Ainuddin Dewan, petitioner versus Haran Ali and others. No,
Have a copy.
My lord, in counter to that, I am.
No, we'll hear it.
Lordship,
We'll hear it.
Lordship.
All right.
A bare perusal of my
Do you have a copy?
Lordship,
Do you have a copy of?
Lordship, yes, the copy.
This one.
This one, this is the one.
I know.
It will. It will.
So Supreme Court decision.
It's Supreme Court decision. I know this.
You read slowly.
Lordship. A bare perusal of Order
Give a
39,
List of book. Why
Lordship,
don't you give a list of book? You can take out the decision if you don't have a second copy. Yes, read it.
Lordship. A bare perusal of order 39 rule 2 will show that the court can grant an injunction either before or after judgment. This power can also be exercised under section 151 of an appropriate case. It is the duty and responsibility of the court to see that an order of injunction passed by it is meticulously implemented or followed. Otherwise, an order of injunction will be a mere paper tiger without having the force to bite. That is not the purpose of granting an order of injunction. An order of injunction creates certain rights and liabilities between the parties, and that order of injunction must be enforced by the court by passing necessary order. That is also necessary to shorten the litigation in as much as if that is not done by executing a decree for perpetual injunction, a person may be put in possession on a particular date, and on the next date by using muscle power, the defendant may again take back the possession of the land. It cannot be the object or purpose of the law. In such a situation, a person so disposes is not to go again for a fresh round of litigation to establish his right and to get the order of recovery of possession. He can approach the court by filing a necessary application under section 151 of the CPC to obtain an order for restoration of possession. And the court in such situation can always give back or restore the possession.
Which court?
It's the executing court.
Where? Where is it in?
There are 17 of reference to the.
Yes.
My lord.
Is it in context of with an executing court?
Lordship, it's executing the court.
Let us see.
Pass the decree.
Judgment. No, where is the reference to an executing court?
9.
111. Execution is an entirely different context.
Entire context. Lordship. After all, justice is our goal. After all, justice is our goal. And to arrive there.
No, we are not on the principles.
Lordship.
Are these principles laid down in the context of an executing court?
It is the court who passed the decree.
Is it an executing proceeding?
Lordship, it is before the execution. It is an executing court because so far this case is concerned, because application was filed under section 151 for restoration of possession.
No, when we have mentioned 121, 32, 151, you cannot just invoke like this. When there is no provision in law, then you invoke 151. That's the settled principle. 151 or not, you cannot invoke just like that.
Lordship, when they are admitting it, so that is why I am going to read it out.
It's a separate power.
So the application is to be filed before the executing court, before the who passed the decree.
Where is the impugned order? Where is the impugned order, Mr. Bora?
Lordship, at page.
My lord, from page number.
137.
Yes. 137 it is.
137, Lordship.
We'll hear this, we'll stay this part. Will be for a counsel for the petitioner. For the petitioner. Also heard. You are in caveat.
Lordship.
You write part 3. R.K. Bhuya, learned counsel for the caveat who has lost this caveat in respect of an order dated 1/6/2023 passed by the learned Munsif number 1, Kamrup M in Miss J case number 389 of 2019 arising out of title suit number 168 of 1998. The caveat would be heard in the event this court proposes to pass an interim order. Caveat can be said in the main right or to be for a learned counsel for the petitioners who have filed this petition under section 115 of the Code of Civil Procedure in respect of an order dated 1/6/2000 by the impute order, comma, the learned court, while allowing the petition filed under Order 21, Rule 32, read with Section 151 of the CPC by the respondent as directed as follows, page 152. Here, page 152, 8 with. Para 3 Bora. The learned counsel has, for the petitioner, has submitted that the petitioners are the legal heir of the original defendant, who is their father. The suit was originally instituted in the year 1998, which was declared in the year 2003. However, on an appeal preferred by the predecessors of the petitioners, comma, the matter was remanded by framing 2 issues, which was accordingly decided by the trial court, and the suit was decreed on 2/6/2006. Sri Bora has informed this court that the appeal by the petitioner, by the predecessor of the petitioner against the aforesaid decree was, however, dismissed on 31/3/2008. He has also, however, submitted that there was no appeal filed on behalf of the plaintiff in respect of any part of the decree. Sarah, it has been submitted that from 2006 to 2019, no steps were taken for execution of the decree, and only in the year 2019, the present application has been filed as stated above. By drawing the attention of the prayer made in the petition, it is submitted that there is a specific prayer for restoration of possession, which he submits was not a part of the modified decree dated 2/6/2006. He has also submitted that in spite of a specific objection taken by the petitioners, the impugned order has been passed with the direction as mentioned above. Issue notice returnable by 4 weeks, by 6 weeks. Sri R.K. Bhuya, learned counsel, has accepted notice on behalf of the sole respondent that an extra copy be served upon him by tomorrow. Third, the learned counsel on the interim prayer. Sarah, Sri Bora, the learned counsel has submitted that the present is a clear case where the executing court has gone behind the decree and has passed certain directions which are not in conformity with the decree. Full stop. He has also drawn the attention of this court to the provisions of Order 21, Rule 32 of the CPC, which provides for the remedies for an executing court in, amongst others, a decree for injunction, wherein the remedy is to pass an order for civil imprisonment, public attachment, or both. Para, per contra, comma, Sri R.K. Bhuya, the learned counsel for the opposite, for the respondent, has submitted that the petition, though was filed under Order 21, Rule 32, comma, the powers, the inherent powers of the court under Section 151 of the CPC was also invoked. And to do substantial justice, comma, the aforesaid direction has been passed. The rival submissions would require a deliberation. Considering the same and to balance the equities, comma, it is directed that till the returnable date, comma, the impugned order dated 1/6/2020 shall remain suspended. You want the date of early hearing? If you want, we can.
Yes, yes.
The suit is a very old one.
Yes, my lord.
List on 4 weeks ago, no? Records will be required or not?
My lord, required, my lord.
Records
the
will be
records
required.
All are annexed.
Even then, my lord.
Well, if it is required, we'll call for later.
Yes,
It's,
kindly it may be called.
Are you disputing any of the documents?
No.
List on the 30th of August 2023, on which date a date of hearing would be fixed.
No.
Depending on the convenience of the party.
Yes, sir. Obliged.
6 weeks. 6 weeks. Then let it be on a date thereafter. Let it be on 8th of September.
Obliged.
Mrs. Satta, you are not where? Now you're okay.
Now I am in.
Yes.
My lord, I am before your lordship against the impugned order dated 10/5/2023.
Page.
But that, my lord, page is 76 to 80.
Hmm.
But before I should take up your lordship to that time in order, I would like to just make a brief history of the case, my lord.
Hmm.
My lord, my own brother filed a suit against me for partition, declaration and partition, my lord.
Just a minute. Who are you?
My lord, I am the defendant, then petitioner, my lord.
Petitioners are the defendants.
Petitioner.
How many petitioners are there?
Two, my lord.
They are the defendants in the suit.
Yes, my lord.
Suit for?
Shoot for declaration and partition and recovery of possession, your own, my lord, of the ancestral property.
Partition and recovery.
Yes, my lord.
Okay.
So, my lord, the father of
How
the
many plaintiffs are there?
my lord,
How many plaintiffs are there?
plaintiffs were 7 in number, my lord.
7 plaintiffs.
Yes, my lord.
All brothers.
Brother and sisters, my lord.
Okay.
Six are the sisters and 1 brother.
And you?
Myself is also the brother of plaintiff number one, my lord.
There are two defendants, you have said, two
Two,
petitioners,
yes,
both of you.
both of,
All are siblings.
yes, my lord, all are the siblings.
The plaintiff, defendants, all are siblings.
Yes, my lord, all are. Seven except the pro forma who purchased 1 bigha of land, my
Doesn't
lord,
matter.
from my father.
Then,
My lord, so at the time of the demise of my father, my lord, he left behind 4 bigha, 1 kattha and 6 lecha of land.
4 bigha,
1 kattha, 6 lecha of land.
6 L. Yes.
Yes, my lord, that land, my brothers have filed the suit for, brother and sister have filed the suit for
Partition.
partition, yes, my lord.
Present suit.
So, yes, present suit. my lord.
This is the subject land. 4
Yes.
bigha, 1 kattha, 6 lecha.
6 lecha.
Okay.
So altogether 426 lecha, my lord.
Oh, yes.
26 lecha, my lord.
Yes.
My lord, the suit proceeded ex parte against me. Against both. And a decree was passed and that decree.
Did you,
your
is expert the issue behind, to be decided? No.
No.
Expert, you allowed to go expert, you do not contest.
No, we actually, we never knew that the suit is filed, my lord.
Okay. That means
Seven except, my lord.
expert is also an issue.
Yes. Ex parte is an
Expert
issue.
against both the respondents, both the petitioners.
Both the petitions. My lord, had the partition been done in accordance with law as per the Islamic law of inheritance, my lord, I would not have been aggrieved. But if I can take your lordship to this, the judgment, and more particularly, my lord, page number 56, page number 56, my lord.
Hmm. Yes.
Then, my lord, your lordship will be pleased to appreciate that the law by which or the order by which the partition is, ordered, appears to be basically wrong. Otherwise, I would not have come before your lordship for. My lord, page 56, the operative part of the order. Accordingly, it is declared that in the result, the suit is decreed ex parte with cost. Accordingly, it is declared that each son of late Pocha Sheikh will get.
Pocha Sheikh is your father?
Pocha Sheikh is my father and the father of the plaintiffs.
Okay.
Inherit 71 lecha land and each of their shares, that is the daughters of late Pocha Sheikh and their mother, who is wife of late Pocha Sheikh, will get and or inherit 35.5 lecha land, each out of the shoot land measuring 4 bigha, 1 kattha, 6 lecha. Accordingly, they have got right, title and interest over their said respective share of land out of the shoot land.
Yes.
Since late Dublai Beva, who is the daughter of late Pocha Sheikh, had died, so her portion of the share measuring 35.5 lecha will go to her legal heirs, who are the plaintiff number 3A, 3B, and 3C. Accordingly, the Deputy Collector Gwalpada is directed to partition the shoot land by metes and bounds as per the share of the plaintiffs and defendants as shown herein above, and shall submit accordingly. So, my lord, whatsoever the share was determined by the learned trial court, as per that, the Deputy Collector is required to partition. But the very share which is shown in that decree, my lord, or the order, that is wrong. Why it is wrong, my lord? Your lordship knows it well that so far the Muslim mother is concerned, wife is concerned, she is entitled for 1/8. 1/8, yes, my lord. 1/8. So she will not get this. She will be getting 53 lecha of land because as per the
Mother is there.
Mother is there.
Your mother is there.
Yes, my lord.
She was a party in this.
Yes, it is mentioned over here, my lord.
1/8 of 526 lecha will be how much?
426 lecha, my lord. And as per my
No, 426 lecha, 1/8 of 426 will be how much?
will be 53.25 lecha.
How much has been given to her?
35.15. Their mother, wife, who is the wife of late Pocha Sheikh, will get and or inherit
And
35.
daughter will get half over. Daughter?
Daughters will get, my lord,
Half.
in that they half of the son's share. Half of the son's share.
And son?
My lord, son will get 71 lecha. And the daughter will get 35.1 lecha. Each daughter, my lord.
No, does the son get any share?
My lord,
How much is the share of a son?
double the share of the daughter, my lord. Because earlier all the property was belonging to the son because they were the warriors. Now from their share, the distribution is made like this. That the daughter will get half of the share than the son, my lord. My lord, should I give that chart, my lord, to your lordship?
I'm having a look at the chart.
Your lordship have
I'm
already.
having a look at the chart.
Yes.
His father is 1/6.
Yes, my lord.
Father is 1/6.
Yes, father is 1/6
Then,
and there is a condition, my lord.
wife will be 1/8, the mother. definitely.
Yes,
Mother
yes.
the petitioner.
Yes.
Then mother is here, not there. That to grandmother is not the daughter is half. Where is son?
My lord, so far, no, my lord, here, the rule of primogeniture is that previously, my lord, all the property was belonging to the son. And this distribution is made as per the Sharia from the son's share, my lord. From the son's, I mean, the total property was belonging to the son, and from there, this division is made, my lord. And so far the daughters are concerned, my lord, you are also pleased to see serial number 7, that 1/2, two or more collectively than 2/3. And my lord, none can exclude this share, save and except the existence of the son, which will make the agnatic heir, my lord.
Now, how much do you, as per your calculation,
Yes, my lord.
the present petitioners are entitled to what share?
71 lecha each,
What has been given to you?
35.1, my lord. 71 lecha, my lord, 71.
To both, to each of the petitioner.
Each of the petitioner will get 71
Now
lecha.
35.5 has been given to you.
Yes. No, no, my lord, it is not like that. First, my mother, who is the wife of Pocha Sheikh.
No, no, we are not on that. As per your calculation,
Yes, my lord.
what will be the amount of measurement of land which will come to you individually? As per your calculation,
71, my lord.
71
First,
letters.
yes, first the mother share will be deducted, and
Understood.
whatever remains, my lord, yes.
And now what, how much has been given to you?
My lord, here it is given 71 lechas. In the order, it is made as 71 lecha, my lord.
Yes,
71 lecha.
yes.
But I am not entitled for 71 lecha. It will be lesser because after the deduction of my mother's share, which comes to my lord 53.1 or 53.25, my lord, then it will remain only 373 lecha.
But
And out,
but has it been discussed in this?
no, my lord, that has not been discussed.
No, no, how is the partition then? How is the share
That
division been made then?
that is, my lord, that calculation is wrong, my lord. That's why I am before your lordship.
No, no, you come to paragraph 12 at page 55. There is a discussion.
Yes, my lord, that's the discussion. I have perused the record and scrutinized the evidence on record, that part, my lord.
Yes.
From the record, pleadings
No,
and
no,
the
that's the thereafter, paragraph 12. It further
it
reveals
further reveals that the
shoot land.
shoot land has not been partitioned amongst the above legal heirs of late Pocha Sheikh. So as per Mohammedan law of inheritance, each son of late Pocha Sheikh will get and or inherit 71 lecha. And each of their sisters, including mothers, will get and or inherit 35.5 lecha land out of the land measuring 4 bigha 1 kata 6 lecha. Here, my lord, this calculation is made wrong because it is not made as
What
per
is the
the
name of your mother?
mother, my lord.
Sarvan. Sarvan Beva.
Yes,
Sarvan Beva
Sharvan Beva
is the mother.
yes, is the wife of yes, man.
Then we come to page 22. Page 22.
My lord.
I think this will support you. You have not shown this.
Page 22, my lord.
Page 22.
Yes,
The first, the decree. Sarvan Beva wife should get 53.25.
yes,
This is what you are contending.
that's what I am contending. Yes,
This is
my
the
lord.
prayer the plaint also.
Yes, yes. So after deduction of that 53.25, my lord, what will remain is 373 lecha only.
Yes.
Now, out of that, my lord, if the sons are allotted 71
Now, this prayer, I think you can take support from this prayer because in the decree, the mother has been, so far as the mother is concerned, it is written 35.5 liters.
Yes. But if, my lord, the total calculation is made as per this, then it will exceed 426 Lacha.
How is it?
Yeah, my lord, uh, if my lord, as per the order, my mother gets 53.25, then 426 minus 53.25 is 373, my lord. And the three sons who have been rather directed to be given 71 lecha each, it comes to, my lord, 213, and 373 minus 213, my lord, is 160. And then my five sisters, if are allowed to get 35.1, my lord, then in that case, 213 again comes in, half the share. So 213, and then 373, my lord, exceeds 426.
But this is a preliminary decree, isn't it? Preliminary.
Yes, my lord, preliminary decree.
How is the revision maintainable?
My lord, revision is, my lord, against section 5 application of the limitation, my lord, which was dismissed.
In the appeal?
Yes, my
You
lord.
have preferred an appeal?
No, my lord, I have not preferred an appeal. Actually, order 9 rule 13 application was preferred, and along with that.
For
my-
setting aside ex parte.
Yes, my lord.
For setting aside ex parte, isn't it appealable?
That is also appealable, my lord.
Then?
And meanwhile, my lord, if my appeal gets dismissed, then I am going to get nothing. But if that decree is set aside, then I will be in a position to.
No, what is your, what is the impugned order here?
Yeah, my lord, kindly come to that, my
You
lord.
have only come against the
Order dated 10/5.
Order 9 rule 13.
No, my lord, I have come against the section 5 application, my lord, of the limitation. Page number 76 to 81, my lord.
76 to 81. We have to file an appeal, Mr. Satra. You know that. This is decided long time back.
My lord,
Radhesham or Shamsundar, I forgot the name.
my lord, during the course of preparation, my lord, I come across one ruling of the Honorable Supreme.
No, it has been settled. I
Yeah,
think Radhesham or Shamsundar, I can give you the citation.
it is Bhanu Kumar Jain, my lord.
What is the citation?
Yeah, my lord, that end.
Name, citation.
2005, 1 SCC,
No.
page 787.
There is a distance. We can give you at 2 o'clock. It's an, no doubt, an order touching the merits of the case. You have to file an appeal. These are well settled.
My lord, let there be show cause and let them appear and show a
File
better
an
case.
appeal. You have to file an appeal.
My lord,
We don't have jurisdiction.
then my lord, liberty to file the appeal.
Obviously,
Yes,
you
my
can get back the certified copy. We can cite the law. Shamsundar or Radhesham, something like that. You are aware perhaps. Third, 3A Sattar, can account for the petitioners who by means of this application has put to challenge an order dated 10/5/2023 passed by the civil judge Gwalpara, whereby the application filed under section 5 of the Limitation Act
My lord.
accompanying an application under order 9 rule 13 read with section 151 of the CPC has been dismissed. Full stop. Sarah, it is a settled position of law that order of this nature is an appealable order, and therefore this petition appears to have been filed, appears to be misconceived. Full stop. Para. Accordingly, the petition is dismissed, giving liberty to the parties to file appeal if so advised. Full stop. The registry, Sri Sattar at this stage praise for a direction to return the certified copy. Put the praise on such application, may return the certified copy.
My lord, the next case is also mine.
Not similar, I hope.
No, not similar, my lord. Not similar, my lord.
It was a case if it don't settle. In this connection, reference will be made to the case of where it has been held as state. Okay. No more particular. Mr. Ali for caveat.
Caveat, Your Lordship, there is a plaintiff responded.
We discharge the caveat first. Heard Sri S. Ali Leonard Counsel for the caveat who has lost his caveat in respect of an order dated 7/7/2023 passed by the learned court of the civil judge Darang Mangalbek in petition number 1591/2023 arising of title execution case number 5 of 2018. The caveat would be heard in the event this court proposes to pass an interim order. Caveat stands discharged. Yes.
May I please, your lordship? My lord, I know that I have lost on all the three fronts from my elder brother, but I am not against the.
You want to lose for a fourth time now?
My lord, if your lordship is not satisfied, then. My lord, here what happened, my lord?
Who are you?
I am the petitioner now before your lordship and the
Understood.
brother of the respondent.
In the suit.
In the suit, I was the defendant, my lord. Title suit, in the title suit, my lord, number 15/1996, I was the defendant along with my father, Dr. Habibullah.
Petitioner and his father were defendant.
Yes, my lord.
Okay. Suit instituted by whom?
Suit was filed by my elder brother, Dr. Ghazi Ghiyasuddin.
Suit by elder brother.
Elder brother.
For?
For declaration of right, title, and interest, recovery of possession, my lord,
Recovery.
and injunction.
Injunction. Okay. Yes.
My lord, the decree is passed. I am not against that. The decree is required to be executed. I do admit to that. But my lord,
Decree for all the counts, right? Title, interest, recovery, injunction, everything.
Yes, my lord. Yes, I'm not. Now, my lord, so far the identifiability of the decretal land is concerned and the house is concerned, I am on that, and that's why I am before your lordship. Now, my lord, if I can take your lordship to the page number 135 and 136. 135, my lord.
135.
135. Because various rounds of litigations were there. 135.
Yes.
My lord, at the time of execution of the decree, I had filed one application before the learned trial court to identify that land. That my petition was rejected, and as against which I came before your lordship by the against the impugned order dated 11/1/2022, my lord.
You're showing 135.
But 135, yes, my lord, 135.
What is it?
My lord, this was the report which was given by the circle officer at the time of execution of the decree, my lord. I'm going to read that report, my lord, before your lordship. It was addressed to the Honorable Civil Judge. A report of title execution case number 5/2018. Letter of the Civil Judge so and so, Darang at Mangalday 13/2/2023. I respectfully would like to inform you that on 22/2023, as per the direction of the Honorable Court, the Nazir along with the Lat Mandal and a team of revenue staff were sent to the Tafsil scheduled land, that upon investigation it observed by the Lat Mandal, as stated in his report, that 16 into 10 feet earthen house with tin roof having wooden post and pakka floor was not found. Report of the Lat Mandal is annexed herewith. Therefore, the 16 into 10 feet earthen house with tin roof having wooden post and pakka floor could not be shown to the Nazir. Therefore, the Honorable Court has been informed regarding the same and the report has been submitted. Now, my lord, this is the report of the circle officer.
Yes.
Mandal has also reported, and that is reflected at page number 37, my lord.
137.
137, my lord. He had reported to the circle officer in this way, my lord, that I respectfully inform you that on 2023, as per the direction of the Honorable Court, the Nazir along with me were sent to the Tafsil scheduled land. That upon investigation, it is observed that the 16 into 10 feet earthen house with tin roof having wooden post and pakka floor was not found. Therefore, the 16 into 10 feet earthen house with tin roof having wooden post and pakka floor could not be shown to the Nazir. Based upon this, the circle officer has given the report, my lord, to the executing court, my lord. Now, after that, my lord, a writ for delivery of position was issued. It is reflected as page number 139.
The bailiff has been directed to do what? For recovery, delivery.
Delivery of position, yes, my lord.
This is dated
That is a,
13/2.
yes, my lord. It is dated 13/2. Report was required to be given by 13th of March 2023, my lord. Now, my lord, the structure which is shown is reflected as page number 143. Showing the area of the total land together with that. My lord, so far E, B, F and C is concerned, that is my area, my lord. I mean the area of the younger brother.
In the map. Not map.
Yes, my lord, that map is shown, it is appearing as schedule 5 or schedule V, my lord.
Yes.
Since the beginning of the plan.
Yes, now what do you want to show?
Now, my lord, page number 145, annexure 15, my lord. Nazir's report. Honorable Judge, that today on the 27/2/2023, I took the Jari Karak along with me to execute the writ of delivery of position, but the Lat Mandal could not identify the land decreed to the decree holder by measuring the same as per the schedule. Accordingly, the position of the land could not be handed over to the decree holder. The decree holder, Lat Mandal, Ward Commissioner, along with the witnesses, have signed the writ. My lord, this was that. Thereafter, my lord, an application was filed by the learned trial, I mean the executing court, by the decree holder, my lord. That is at annexure 6, annexure 16, page number 147. My lord, I would like to read that, and thereafter what was the order passed, my lord.
Okay. Under 21, rule 35.
Yes, my lord. My lord, that the decree holder has plaintiff instituted, para number 1, my lord. That the decree holder has plaintiff instituted a suit being title suit number 15 of so and so before the honorable court against the judgment debtor and others for a decree of declaration of title, recovery of possession and permanent injunction and for other reliefs. That the honorable court by judgment and decree dated so and so decreed the suit of the decree holder declaring the plaintiff's title to the suit land as described in schedule 1 and the house as described in schedule 2, evicting the defendant number 1 from schedule 5. So schedule 5 or schedule V
Five.
Yes, 5 was that part, my lord, wherefrom I was required to be evicted as per the decree, my lord. And delivery of the khas position of the above house to the plaintiff together with a permanent injunction restraining the defendant number 1 from interfering with the position of the plaintiff and also from making any further construction over the shoot land. The schedule of the decretal land and houses are as follows. So, my lord, this is the replica of that which was already mentioned in the plain as well as in the decree, my lord. And here also your lordship will be pleased to find schedule 5
Yes,
in the
please.
same fashion.
Page 59 is the prayer, 159.
Yes, my lord. Now, my lord, one. Yes. It is therefore prayed that your honor may be pleased to issue a writ of delivery of possession to the decree holder by demolishing and dismantling the recently constructed new semi-RCC, the roofed house by the judgment debtor by illegal and unlawful means, and the decree holder may be given possession thereof for the ends of justice. I am only against this, my lord. My lord, I have not constructed any house. The house which was alleged to be there in the year 1995, my lord. From that, rather, I was required to be evicted. Now, this is a further prayer made, and without, my lord, adjudicating this part of the matter, my lord, again the writ is issued and the order was passed on that, my lord. I am taking the honorable court to that impugned order, which is at page number 164, my lord.
77.
My 77. Decree holder is represented. The order is in relation to the petition number 159123. The decree holder of this case has filed an application under order 21 rule 35(3), read with section 151 CPC. The decree holder states that he filed title suit number 15/1996 and this court decreed the suit on 14/5/2009, declaring the plaintiff's title to the shoot land as described in Schedule 1 and the houses as described in Schedule 2, evicting the defendant number 1 from Schedule 5 house and delivering the khas position of the above house to the plaintiff together with permanent injunction, restraining the defendants from interfering with the position of the plaintiff and also from making any further construction over the shoot land. Schedules of the land are described in the petition. It is stated by the decree holder that the judgment and decree was challenged through appeals by the JD, but the appeals were dismissed by the Honorable Guwahati High Court as well as the Honorable Supreme Court. The decree holder having filed an application for execution, judgment debtor appeared in the execution proceeding and filed an application under section 47, read with section 151 of the CPC.
We have read this. What is your case now? Tell us.
My lord.
What are your grounds of challenge?
My lord, let the decree be executed, but with the proper identification of the scheduled land. Because, my lord, prior to this, I had also made an application under the RTI, to the Mangaldevi Municipal Corporation, our municipality, and where they say that there is no house ever assessed in the name of Dr. Ghazi Ghiyasuddin, which can be said to be Schedule 5, wherefrom I have been directed to be evicted. So my respectful submission before your lordship is only one, that the decree, once the decree is passed, it is required to be executed. But it will be executed only on the schedules which have been decreed, and that too by proper identification. Nothing more than that I can deserve, or nothing more than that I require. Simply I require that the decree at the time of execution, because my house is just contiguous to the scheduled shoot land, my lord. If under the garb of that, if my house is demolished, then I will be at great distress, my lord. So I want that let the decree be executed, but with the proper identification, my lord. Whereas the report is contrary to that, circle officer reports like that, Mandal reports like that. Gaon Buddha, our ward commissioner, was also there, my lord.
Okay.
That is my.
Okay.
May it please just lordship, this defendant, your lordship, present petitioner before lord, He lost before the trial court, first appellate court, second appellate court, your lordship, in the Supreme Court also. Thereafter, he lost in another civil division petition, your lordship, recently, your lordship, in the month of February. Now, under the guard of section 47, he is repeatedly, your lordship, questioning the identification of the land. So identification of land, it is not necessary. Why, your order? Land is covered by boundary walls. Land is covered by boundary walls. His land is on the eastern side. Your lordship, kindly come to page 151, your lordship. It will make the matter clear.
121,
151, your lordship.
151.
Yes, sir.
Yes.
151, your lordship, this page, your lordship, there is a sketch, your lordship.
Yes.
So the cross portion, your lordship, that is 1 acre of land. Whereupon the court has declared my right, title and interest.
AEDF.
ADFE. That is cross portion, your lordship.
Yes, that is your.
Blank portion, your lordship, that is 2 quota 10 lessons. This plaintiff, your lordship, he was the owner of 1 acre 2 quota 10 lessons of land, entirely. So in a family settlement, your lordship, my father asked me that you give him his younger brother, so you give him some land out of this 1 acre 2 quota 10 lessons.
This entire plot A, B, C, D is 1 acre 2 kata.
1 acre 2 quota 10 lessons.
A, B, C, D.
1 acre 2 quota 10
1 acre
lessons.
2 kata 10 letters.
10 lessons, your lordship.
Earlier, you were the absolute owner of the entire land.
Correct, your lordship.
Thereafter, family's arrangement was made.
Family arrangement, your lordship. Other properties were also partitioned, your lordship.
Yes.
Agricultural land has been given to him, your lordship.
Okay.
Here. So this 2 quota 10 lessons, he was given on the eastern side, and he has constructed his own houses
2
in the
kata
your lordship. 2
10
quota
letter.
10 lessons on the eastern side.
Given to defendant.
Dependent now, dependent, your lordship. 1.
That means this is EBCF.
Lordship. Lordship.
EBCF given.
Lordship. Now, the lordship, he has constructed his houses in structure here, your lordship. So for the 1 acre of land is concerned, there are some old houses in structures as per the partition, your lordship. I got all the structures, including the Heki, your lordship, including the greenery house, your lordship, everything, your lordship, as per the settlement, I got it on this 1 acre of land situated.
Which is 1 acre?
This 1 acre is sketch, your lordship, that is
Okay, that is within this 1 acre.
lordship.
Out of, you want to contend that out of the total area of 1 acre 2 kata 10 letter,
Correct.
2 kata 10 letter is the blank portion, which has been given to Mr. Satra's client.
Center
And the remaining 1 acre
is my land, your lordship.
your land, which includes all the other part which you just said.
Lordship, whatever is there, you are over it.
Okay.
So there is a main dwelling house. That is also in my occupation, your lordship, that is still there under lock and key. Your lordship know Dr. Ghazi Ghiasuddin Ahmed, that is a famous radiologist in northeastern region, your lordship. All his doctors, his sons doctors, daughters-in-law doctors, he wanted to construct a DRL up to that modern pathological laboratory, your lordship. That could not be done because of the defendant's sinister, your lordship, desire to frustrate. Anyway, your lordship, that till today, your lordship, he has not been able to, he is now 85 years. So his sons, they are taking steps, all doctors, your lordship, could not be successful. And this gentleman, defendant number 1, your lordship, he has harassed extremely. This is an extreme case of abuse of the process of.
No, that is your submission.
Correct.
What do you submit
Now
on the facts that the land has not been identified, but it has been issued.
Hello, I am coming, your lordship. What happened, your lordship? As we are permanent resident of Guwahati, so he was there, your lordship, in the Schedule 5 house. Schedule 5 house is measuring 16 into 10.
Correct.
At that time, your lordship, he had no house at the time of family settlement. At the time of family settlement, he had no house. So this house, as per the request of my parents, your lordship, who are defendant number 2 and 3. So I allowed him to stay there.
16 by 10 house.
6 by 10, that is Schedule 5 house. I allowed him to stay there.
This falls within your area.
Lordship,
This falls within the shaded area.
the schedule one, your lordship,
No, this house, schedule 5, 16 by 10 house.
and yes,
fall- falls
within schedule one,
The shaded area.
my
One big
area,
area.
my area, your
One big
lordship,
area.
schedule one, yeah, this is my area, my land. There was other structures, your lordship, everything your is put in my, fell in my share, your lordship. Anyway, your lordship, as there was a house measuring 16 feet into 10 feet, he had no house at that time, your lordship. I allowed him to stay there, your lordship. Now, after the death of I allowed my parents, your lordship.
Just, Mr. Ali, if you come to 151, page 151,
False.
this is the same house which has been described under schedule 5. Please come to 151.
Description of the house from which the
Yes,
dependent
this is
number
the
one
house
is sought
you're-
to be
this-
evicted.
this
A
is-
one-room Assam type dwelling house, asbestos roof, wooden frame, post, pakka floor.
This is the house you are referring
This
to.
is the house, it falls in my share.
Okay.
It falls in my share. Yeah. So he was allowed to stay there because at that time he had no house in the eastern portion. That is, in the eastern portion. He developed with your lordship, he shifted there also, but that room measuring 16 feet into 10, your lordship, it is in his possession. So he was requested, your lordship, after the death of my parents, because my parents were allowed to possess the main house, your lordship, though it is in my share, as they are old enough at that time, because I don't like to disturb their position, they will be there, your lordship, till their death. So after that death, your lordship, I entered into possession of the main house, and he was asked that as you are having your own personal plan, that is eastern side, 2 katha, 10 lesser, your lordship, so you sit there. So he did not sit, rather he, your lordship, denied my right title, your lordship, and he this way, that way, your lordship, so many things your lordship did. And he also constructed a house that was demolished, your lordship. Now, so far decree is concerned, your lordship, my learned friend says that we have no objection. So if you have no objection to the decree, if it is not a nullity, your lordship, if the decree is not a void ab initio, then you are duty bound under the decree, your lordship, you are duty bound under the decree to vacate it, like a gentleman. If you don't vacate, then I have a right to pursue the matter in litigation. So I have been involved in the litigation. He dragged me to file a suit, your lordship. Since 1996 till today, your lordship, 29 years. It is 29 years, your lordship, I am fighting this. Now, one after another, your lordship, he is coming to the court. He is getting stay also, your lordship. Sometimes, your lordship, every time he has lost. Now, question is, you know, in the last occasion when the Nazir came to execute the decree to evict him from the place, your honor, that is 16 by 10 feet house, your lordship, it was found by the Lord Mondal, your lordship, that that house is not there. So our this eldest son of my Judge Giyasuddin, he was there, but it was there during the trial, during the passing of the decree. But after the decree was put to execution, your lordship, thereafter it is not there, and we did not know because we are not permanent resident of here. And he has done it. And recently he has done one semi-RCC house, your honor, in the same place. He's so clever, your lordship. Somebody has definitely, your lordship, it might be advocate, your lordship, that you replace it. The former tin roof house, this pakka floor, all these things, you remove it, you construct a new house. Then this decree will not cover it. Now that definitely that gentleman, whoever he might be, either petition writer or advocate, does not know that there are number of decisions of Supreme Court, High Court, your lordship, if during the pendency of the suit or during the execution any new structures is constructed, either replacing or without replacing, that can be removed.
You cannot circumvent the decree by constructing something new or changing the nature of it.
Lordship,
You cannot circumvent the decree. Decree has to be executed.
Lordship, Did, you know, so our, the recent decision of the Supreme Court rendered by Amitabh Roy, Your Lordship. That is the landmark decision, Your Lordship, that a decree is a sacrosanct.
Yes.
I am giving Your Lordship. The decree is a sacrosanct. It must be executed at any cost. Because if it is not nullity or a void ab initio, so it is the duty of the executive court to execute it at any cost. No plea of the, and 47 cannot decide the fate of the case. 47 cannot frustrate or defeat the decrees at any rate, Your Lordship. I am giving Your Lordship. Yes.
Yes.
Now, Your Lordship, when
Which paragraph?
Your Lordship, paragraph I am giving Your Lordship.
It is 21.
Number, yes, Your Lordship, 21 and other paragraphs also, Your Lordship, because moonlight. This paragraph 21 and 22, Your Lordship. 2017 5 SCC 371. Paragraph 21 and 22, Your Lordship. These are sacrosanct. So it must be, sacrosanct means, Your Lordship, there cannot be any alteration or anything like that, Your Lordship. It must be in veto, must be executed. Your Lordship will go to you. Now, Your Lordship, what happened, Your Lordship? Fine. From the report of the, it is an extreme abuse with the process of court, Your Lordship. Why? I'm telling Your Lordship, he is to vacate it, Your Lordship. He is a gentleman, Your Lordship. Respecting his elder brother, Your Lordship, he is to vacate it. He has lingered it for 29 years. He has been successful. So far his attempt is concerned. Now, Your Lordship,
47 powers are very limited. Objection. Only when the decree is
Microscopic, Your Lordship.
can be shown to be
It is
a
microscopic.
nullity, then only
Yes,
executing
Your
court.
Lordship.
Otherwise,
It is microscopic, Your Lordship, and has been observed, Your Lordship. Now, Your Lordship will come to page.
but Mr. Sattar has taken up some specific grounds. How do you deal with your objections? They are in general in nature that he is trying to thwart the decree and prolong the case. But he has taken up some specific grounds of challenge that while the decree was being put to execution, the house from where he was directed to be vacated, that house is not there, and in some other house is there,
there, Your Lordship.
which is not matching with the description which you had made in the plane. You may be right that by some advice, he has removed the earlier structure and taking advantage of your absence from that place, he has constructed a semi-permanent kind of a structure.
Lordship. Lordship.
Now, decree is silent on that part.
Lordship.
Obviously, because at that time that structure was not there.
Lordship. Now, Your Lordship will find from the report of the circle officer.
Yes.
At 135, page 135.
135.
135.
Yes.
Respectfully beg to inform, it is addressed to the Honorable Civil Judge, Your Lordship. Respectfully beg to inform, like to inform you that on such and such as the direction of the Honorable Court, the Nazir along with the Lot Model and a team of the revenue staff were sent to the Tafsil land. That upon the investigation, it is observed that the last Lot Model as stated in his report that 16 feet into 10 feet earthen house, that is earthen means your lordship, that is asbestos house with tin roof having wooden post and pakka floor was not found. Report of the Lot Malik annex herewith. Therefore, the 16 feet, 10 feet earthen house with tin roof having wooden post and pakka floor could not be shown to the Nazir. So, as the house has been demolished during the pendency of the execution process, definitely house will not be there. And who has done it, your lordship? Because we are permanent resident of Guwahati. Definitely he has done it, your lordship. Demolition, he has caused, your lordship. He has demolished his lordship and he has constructed newly. We have stated in our petition specifically, your lordship, that newly constructed, as we have seen, newly constructed out, it is not an old house because old house is before 1993. So it is not a house of 1993, your lordship. The court has given a finding that it is a new house. Court has given a finding that what will happen, your lordship? Does it mean, your lordship, that will not be affected? Supreme Court says that under Order 21, Rule 35. So there are some ancillary powers, your lordship. Incidental powers, your lordship. Inherent powers, your lordship. These are the three things Supreme Court has held, that if construction is made during the pendency of the suit or during the execution proceeding, your lordship, it is to be demolished, it is to be removed from there, and there is no bar as such, your lordship. The plea which has been taken, your lordship, this decision will remove the cloud, your lordship, remove the doubt. This Supreme Court (235).
And you are referring to Order 21, Rule 35.
Lordship.
Please read.
53, your lordship.
Order 53.
Okay. 35, your lordship.
Decree for removal property.
Where a decree is for the delivery of any immovable property, possession thereof shall be delivered to the party to whom it has been adjudged or to such person as he may appoint to receive delivery on his behalf, and if necessary by removing any person bound by the decree who refuses to vacate the property. Where a decree for the joint possession so and so possession shall be delivered affixing to. Where possession of any building or enclosure is to be delivered. 3, your lordship.
Yes.
And the person in possession being bound by the decree does not afford free access. The court through its officers may, after giving reasonable warning and facility to any woman not appearing in public according to the customs of the country, to withdraw, remove or open the lock, bolt, or break open any door, or do any other act necessary for putting the decree holder in possession. So other act means, your lordship, ancillary, your lordship. Supreme Court has said, your lordship, that it ancillary in your lordship will come to the para 8 of the decision, your lordship. Incidental ancillary, your lordship.
You are referring to 1995.
Lordship, this says 1995 5 SCC 238. Para 8. Got it, your lordship. Right. Rule 35(3) of Order 21 itself manifests that when a decree for possession of immovable property was granted and delivery of possession was directed to be done, the court executing the decree is entitled to pass such orders incidental, ancillary, or necessary orders for effective enforcement of the decree for possession. The power also includes the power to remove any obstruction or superstructure made superstructures, your lordship, engineer, possession of the property, includes power to remove any structure, obstruction, superstructure made pendently like. Made pendently like, that means, your lordship, execution proceeding or dependency of the suit. The exercise of incidental, ancillary, or inherent power is consequential to delivery of possession of the property in execution of the decree. No doubt, the decree does not contain any mandatory injunction or demolition. But when the decree for possession had become final and the judgment debtor or a person interested claiming right to the judgment debtor has taken law in his own hands, the lordship, it is important, in his hands, and made any constructions on the property pending the suit, the decree holder is not bound by any such constructions. The relief of mandatory injunction, therefore, is consequential to or necessary for effectuation of the decree
For
for possession. It is not necessary to
file a separate suit.
file a separate suit, your lordship. So it comes within the incidental, ancillary, inherent, and if during the pendency of the suit, including this execution proceeding, as my learned friend's client, your lordship, has done, your lordship, he is very clever man, your lordship, definitely he has taken this sort of vices also from somebody. Now these vices, your lordship, as per this, he has constructed after demolishing. Now in the written statement, your lordship filed that Cyril is not wrong. Cyril is there. He never said that there is a semi-RCC building in the written statement. He has admitted, your lordship, that 16 into 10 feet house is there. It is his possession, your lordship, as permitted by the plaintiff, this respondent, your lordship. Now, where from this semi-RCC building came, your lordship, and why this 16 by 10 feet house actually now there? Where has it gone, your lordship? Is there any explanation, your lordship? Because he is all along in possession. So far the main house is concerned, other land is concerned. It is in my possession. Only used to be, your lordship, removed, and this house has been, which has been later constructed, your lordship, that is to be removed. Huh? So for the identification of land is concerned, your lordship, it is not at all disputed, and he has not disputed also. Identification of the land. It is enclosed by boundary wall. My 1 acre of land, your lordship, it is on north, south, and east. It is bounded by brick walls. On the west, your lordship, main road, your lordship, it is open. So far his land is concerned, 2 quarter 10 lesser, it is all along, there is boundary wall. There are 2 other decisions, your lordship, on the same point. Lordship, para AR 1880 Patna, your lordship, 197. Paragraph 8 and 9, your lordship. Eight, your lordship, will find. Also got it. Yeah, 1980. Now I proceed to consider the main question as to whether the courts below should have ordered for removal of the structure in course of affecting the delivery of possession of the land in question. Here it is land unit. The relevant provisions is contained in Rule 35 of the Order 21, which deals with the mode of executing a decree for possession of immovable property. The Court of Appeal below has noticed some cases on the point, but all these cases are between the landlord and tenant, and in my view, the principle laid down in those cases will not apply. The situation in the case before us. The only question that has to be decided is as to whether while executing a decree for recovery of possession of the vacant land, the executing court can direct for removing the structures. Such structures may be put up by the judgment debtor before the institution of the suit or pendently, and after the decree. In their objection to petition, judgment debtor had pleaded that the construction in questions were put up by them months before the suit. The decree holder in his rejoinder, however, controverted the position and contended that structures were put up after the passing of the decree. There is no express finding on this question of either of the court below. As already seen, they proceeded entirely from a different angle to answer this question. It cannot be disputed that where the defendant puts up construction pendently like or after the passing of the decree, then executing court can order demolition of the structures and deliver vacant possession thereof. Now I'm coming to the 9, Your Lordship. From the perusal of Order 7, ordered Lower Appellate Court, however, I find that it has come to a conclusion that the two switches were constructed by the judgment debtors during the pendency of the suit. Although some other structures were already there from before, the decree holder has paid for delivering vacant possession over the land on demolition of two dosaras only, which according to the above finding were constructed pendently like. In that view of the matter, I will allow this appeal and direct the executing court for giving possession of the land after removal or demolition as the case may be of the two dosaras. With this, Your Lordship, with respect to this construction, if any already on the land from before, it would simply allow some reasonable time to the judgment debtor to remove and make the matters of the state structure. I find support of this view from the case from so to Your Lordship. The next one, Your Lordship, same case, Your Lordship, that is AR 1970 Allahabad 648. That decision has been followed in this decision of Part 9, Your Lordship. And so far the paragraphs are concerned, it is 5, 6, and 7. AR 1970 Allahabad
648.
Lordship 648.
Para?
Yes.
5, 6, 7.
5, 6, and 7 paragraph, Your Lordship. 5, Your Lordship. On the application of the rule of equity, no party can be permitted to take advantage of the wrongful acts committed during the pendency of a suit. The same principle can be inferred from the provisions of Section 52 of the Transfer of Property Act, which clearly provides that during the pendency of any pendency in any court having authority of a suit or proceeding in which any right to immovable property is directly and specifically in question, the property cannot be transferred or otherwise dealt with by any party to the suit or proceeding, and so as to the effect the right, so as to affect the rights of the other party under any decree or order which may be made therein, except under the authority of the court and on such terms as it may impose. The words otherwise dealt with are general and can also include raising of constructions wrongfully when the defendant could not in any manner deal with the immovable property in dispute in the suit. He cannot to the disadvantage of the plaintiff declared their claim any advantage out of the construction wrongfully made. 6, if it were necessary for the plaintiff always to institute a new suit with regard to any wrongful act during the pendency of the suit, the litigation would never come to an end. Litigation would never come to an end and itself open to the defendant to cause an irreparable injury to the plaintiff. In the circumstances, I see no difficulty in executing court ordering the removal or demolition of the construction made during the pendency of the suit during the execution of a decree for possession. So here is the case, Your Lordship. The present writ of delivery, Your Lordship, has been to be issued, Your Lordship, on the plea, Your Lordship. Decree holders claim that the removal of the earlier house and the construction of a new house in the same place, Your Lordship, that it is nothing but a new construction during the pendency of the either suit, but in our case, it is during the pendency of the execution proceeding, Your Lordship. So it is as an incidental, inherent, and ancillary matter, Your Lordship. So it can be demolished, Your Lordship. It can be dismantled, Your Lordship, and possession can be given to the decree holder for smooth enjoyment of the decree, ardent decree, Your Lordship, having fought for last, in our case, Your Lordship, 29 years. Now they are enjoying, Your Lordship. Repeatedly they are disturbing. And if this disturbance, Your Lordship, it is allowed, Your Lordship, then there will be no end to it, as this decision has suggested, Your Lordship. So 7, Your Lordship, where the constructions were made before the institution of the suit, the rule laid down by the Rangoon case could be adopted, but where the constructions were made during the pendency of the
we have read this. So, is there any dispute regarding the existence of the house in the plan, the sketch at 143 within your area? Kindly pick up 143 again. 143. That sketch.
Lordship.
Now, it contains a whole area A, B, C, D.
Lordship.
Out of that, you have said that you had given A, B, C, D is 1 bigger, 2 katha 10 lecture. And out of that, 2 katha 10 lecture, the part which has not been shaded has been given to
belongs to defendant.
Now, in the shaded part, you had given him a house to stay, 16 by 10, which was also directed to be given to as per the decree. It falls in the decreed land. Now that house is missing. Now the report is that some semi-permanent houses come up. Now, has the semi-permanent house been constructed within A, E, F, D?
Lordship.
Is there any dispute to that proposition?
There is no dispute, Your Lordship. Now this A, D, F, E, Your Lordship, this is my property.
Understood. Now the question is this, whether the house presently existing with some permanent structure kind of.
Other houses.
The new house.
Semi-permanent,
Yes.
Lordship.
Has it been constructed in the shaded part, or is it constructed? Is there any dispute regarding the area where it is constructed?
No, not disputed part, Your Lordship. This is my part, Your Lordship, where decree has been passed, Your Lordship. That is Schedule 1. Schedule 1 is the A, D, F, E,
Yes,
Your Lordship.
then probably they will not have any difficulty.
So this part is my part, Your Lordship. So he is to vacate like a gentleman. If he does not vacate, Your Lordship, then decree
There is no averment.
will be executed.
There is no averment from the other side that the house is on EBFT on his part. It's not the case of the.
Semi-RCC building, it is, they have set up the case, Your Lordship. If that is so, they are to explain where is the 16 by 10 feet house.
We are not on that. We are not on the existence of the new structure and demolition of the old structure. Perhaps that has happened that he has demolished the earlier structure and has constructed a new house. We are only on the site of the house.
Lordship.
whether it is in the shaded part or whether it is in his part.
No, not in his part, your lordship, not in his part, because if it is in his part, definitely he can't come to the High Court, your lordship. Or before that court, so he can't say that it is in my part. It is not his,
Because
part,
Mrs.
but
Khattar
it is in the
is
part.
emphasizing that it is not identified. That he is trying to build up a case that without identifying the land, the decree is thought to be executed.
There, decree is not for identifying, your lordship. He has misconstituted, your lordship, this Nazir's report. There is no question of
No,
identity.
that part we have accepted your case because in the written statement, there is no denial of the schedule.
Everything has been admitted. Only thing, your lordship, that
Okay. Yes. Anything, Mr. Sab-
My lord, I will take your lordship only 2 minutes time, my lord.
anything left, Mr. Ali? I think we have heard you. Is there anything more you want to submit?
complete lordship, provided your lordship said that actually, your lordship, there is nothing to be heard from my side. All right.
My lord, your lordship have, so far the ratios of the cases are concerned, be it ratio decidendi or be it obiter dicta, my lord. I am totally agreeable to that. I cannot dispute that. But where I am, my lord, if I can take your lordship to page number 151 again, which was not replied by my learned friend. Page 151, my lord.
Yes.
Schedule 5, my lord, has 3 parts.
2 part.
In fact, my lord, it has got 3 parts, 1, 2, and 3. Schedule 5, my lord, page number 5,
Yeah.
151. A one room that is already explained, my lord. It bears to my lord holding number 237 of ward number 2. Am I right, my lord? A one room type dwelling house, asbestos roof, wooden frame and post, pakka floor measuring approximately 16 into 10 towards the eastern side of the main house, covering by holding number 237 of ward number 2. Now, my lord, there is a sketch, site plan.
Yes.
So in all respect, my lord, holding number 237 of ward number 2 must have the area of 16 feet into 10 feet.
Yes.
Yeah. My lord, now come to the last line, my lord. The land marked with letters A, B, C, D,
Yes.
is the land purchased by the plaintiff on 7/10/67.
Yes.
No dispute. B is 2, my lord. The land marked with letters A, E, F, D is the shoot land.
Yes.
So this shoot land ought to have been only for 1 bigha of land, my lord.
Yes.
Because of the second contention,
Yes, the AFD is 1 big. There is no dispute.
yes, one bigha, my lord. Now the land measuring 2 katha 10 lecha marked with letters E, B, C, F is the land allotted to the defendant number 1
Yes.
in the family settlement so and so.
Yes.
So out of 1 bigha 2 katha 10 lecha, my lord, as per the version of the plaintiff decree holder, 2 katha 10 lecha of land was given to me.
Correct.
Now, my lord, kindly turn to page number 128.
128.
128, my lord. My lord, if I am sinking in the ocean, I shall have to do something. So I have done it, my lord.
Yes.
My lord, I made an RTI application to the commissioner or the public information officer, Mangaldevi Municipal Board, my lord. And this is the report of that.
Yes.
My lord, I am simply referring to that report. With reference to the subject cited above, I have collected your required information report under the RTI Act 2005 from the office of the Mangaldevi Municipal Board and forwarded the same for your information as follows. Information report is, my lord, the holding number 2/2237 is in the name of Ghazi Gyasuddin Ahmad, son of Habibuddin Ahmad, ward number 2, Mangaldevi, land 1 bigha 2 katha 16 lecha. How that can be, my lord? And there is my cause that when
Who is Ghazi Gyasuddin?
Ghazi Gyasuddin is my brother, I am the plaintiff. Yes.
Mr. Ali's friend.
Yes, my lord. Though my learned friend has spoken very high about him, I also admire by
Lordship,
that.
these are beyond matter records, your lordship. These are not
This is
matters to be decided here. It is not his case, your lord, before this.
Then how my 2 kattha
Why
10
you are-
lecha of land,
You
Let
failed
him
to,
submit to it.
you could not.
Let him submit.
my lord,
No, no, these are wastage of time, your lord.
let the honorable court say that it is the wastage of time. You are nobody to say that it is the wastage of time. When, my lord, the very 151 page speaks of that out of 1 bigha 2 kattha 10 lecha of land, 2 kattha 10 lecha is given to me, and it is belonging to me, my lord, as per the family settlement. Then how Ghazi Gyasuddin got it assessed, the entire land in his name in respect of holding number 237 of part number 2?
Mr. Satta, are you denying that you are not in the owner and possession of EPCF?
I am
You are not denying.
No, I am not denying. My house, my lord, is there on that. That's why I am made a respectful submission before the honorable court that there should be some proper demarcation of 1 bigha of land, so that should be given to him. And if there is any house of mine, let it be demolished. I will never mind. But my lord, under the garb of that decree, my house should not be demolished, which is situated at 2 kattha 10 lecha of land.
Where have you stated? Let us see your statement.
No, my lord,
Your statement that you have a house which is within 2 kattha 10 letter and is about to be demolished because of this decree.
no,
Where
that
is
I
the
have,
apprehension?
because that opportunity is not given to me, my lord.
Why?
Let me take the honorable court, my lord, to that petition which they have filed, and immediately thereafter the order is passed. No chance is given, my lord, to me by the executing court. Simply on the basis of the application filed by them, the order is passed.
That's it.
And now, my lord, kindly come to the operative part of the order at page number 167.
No, 147. This petition 1591 of 2023 was presented on 22nd of June 2023.
Yes,
And the order has been passed on 7th of July 2023.
my
It is
lord.
not passed on the day when this petition was presented.
No, but on the basis of that application, I was not given the opportunity to show my cause or to file any objection, my lord.
You were heard.
No, my lord, I was not heard, my lord. Only decree holder is represented, my lord. I was not heard, my lord. Had there been any opportunity given to me, my lord, I would have replied to that petition 159, my lord.
Where have you stated here in this petition on this, that in this petition before the High Court, that you have a house which is thought to be affected by execution of this decree?
My lord, say for example, my
No,
lord,
have
I will
to-
take your lord.
See the pleading.
Yes, I will
Those
take
pleadings
your
will
lord.
not have any meaning in a revision court. But
The-
you want to say, see what have you stated on affidavit?
The grounds, my lord, which I have
No,
taken.
that's the factual position that you have a house which is within the sketch portion.
No, my lord, take it in this way, my lord, for a second, that even if I don't have a house and the land within 2 kattha 10 lecha belongs to me, does it not require to be demarcated at the time of handing over possession of 1 bigha of land to the decree holder?
The lands are bounded by boundary walls.
There is nothing like that, that the lands are bounded by the boundary wall, my lord.
That was never an objection.
There is nothing like that, my
There was
lord.
never an objection. Can you just,
Both are contiguous to each other, my lord.
objection cannot be invented at a later stage. If there is an objection, it will be there from the initiation. At the stage, in the present stage, can you come up with that?
My lord, I have taken that into the ground portion, but the fact remains, my lord, that out of 1 bigha 2 kattha
And
10
you
lecha,
have the remedies in law. If a decree, in execution of a decree, something which is more than the decree is thought to be affected, you can come before the execution court.
no, my lord, that
As a
opportunity was
revision
not
court,
given.
do you have the powers?
Yes,
Go
my
into the
lord,
nitty-gritties, to the thick and corner, everything.
my lord,
Order
for
that
1
you
second,
give-
kindly come to page number 167, my lord, the last part of, yes,
167.
yes.
Yes.
The last part of the order.
Yes.
Therefore, it is directed upon the civil Nazir to execute the writ of delivery of possession to the decree holder by demolishing any structure if found on the decretal land.
Decretal land.
Yes,
That's all.
Correct.
Where else?
Decretal land, my lord. Yes.
If it exceeds
So
the,
the
if it
decree,
exceeds the decreted land,
yes,
you have the remedies in law.
my lord, after losing everything, if I have the remedy at law, my lord, then
You have
what
the
will be
remedy
that remedy, my lord?
Your bona fide seems to be, has come to doubt.
Furthermore, my lord, it says that demolishing any structure if found on the decretal land after identification of the decretal land by a specific boundary. And while doing so, assistance of police, any expert relating to demolition of construction can be taken by the decree holder by payment of appropriate so and so, so and so. Therefore, it is directed that the writ is to be issued in consonance with the order passed today, and the decree has to be, holder is to take a step. So that portion of the land is required to be kept aloof from the execution proceeding, my lord. I am not against the execution of the decree. Let him get the fruit of it.
We'll pass orders, final orders.
Oblige, your Lordship.
We'll liquidate the order at 2 o'clock. In the courts.
Oblige, your Lordship.
So at two, I think.
At 2. You may not be there, your because you can be there. Yes,
May I please, your lordship? Lordship, my order 41, rule 27 petition was rejected, lordship.
Lordship, the issue has been settled, Lordship.
yes,
Several cases has been seized,
Yes,
appearing in
Yes, Lordship.
all the cases, Lordship.
yes. That railway case, last occasion you had a prize.
Yes, lordship. The order will be same, lordship, only the petition number will be different. 954.
At that number. 13. Third, MS F Ahmed. Then it counts. Separate order for the petitioner. Whereas the railways, correct,
Lordship.
are represented by Sri P. Chakraborty, Planet CGC. Full stop. There are, considering the nature of challenge and as agreed to by the parties, comma, this petition is taken up for disposal at the admission stage. Full stop. That the projected case of the petitioner is that an appeal was preferred under section 9 of the Public Premises Eviction of Unauthorized Occupants Close Act 1971 before the learned district judge Jorhat, which was numbered, which was registered as Miss Appeal number 38 of 2018. In along with the state appeal, comma, a petition was filed being petition number 944 of 2022 for under order 41, rule 27 for allowing the petitioner to adduce additional evidence at the appellate stage by examining the senior divisional engineer of the northern of the NF Railways, who had furnished certain information under the RTI Act. The aforesaid prayer made for adducing evidence that the appellate case, however, has been rejected by The impugned order dated 16/12/2022. Put the para. I must submit the learned counsel submit that the appellate court ought to have exercised the aforesaid powers for for calling for and allowing the affected party to adduce evidence at the appellate stage in the interest of justice. Put the- She accordingly submits that necessary order of interference be passed. And the application filed at the order 41 rule 27 be directed to be considered in accordance with law. Para or contra. Come on. Three. Chakraborty. The learned thesis has, however, submitted that the issue raised is no longer res judicata. Full stop.
Same common order, Lordship, only the case number is different.
Where?
Or Lordship will find the order dated 16/12. Same 16/12 order. Only the appeal number is different. Same passed by the district judge Jorhat.
He submit that the Honorable Supreme Court in the case of Adi Sami Tudikalaba, 8 versus 20, has laid down that admissibility of evidence does not depend upon the relevancy of the issue on hand or on fact, whether the applicant had an opportunity for adducing such evidence at an earlier stage or not, depends upon whether or not the appellate court requires such evidence to enable pronouncement of the judgment or for any substantial cause to suffer. In a similar circumstance, there was a rejection of an application made under Order 41, Rule 27, which was the subject matter of dispute. And this court, by many orders, isn't it? By certain orders, including an order dated 27/2/2023, passed in CRPIO 58 of 2020, had rejected the petition. This court is also of the opinion that application of application of Order 47, Rule 20, Order 41, Rule 27 cannot be done in a routine manner, and the conditions laid down in the state provision of law are required to be fulfilled. For any reference, the state provision of law is expected herein below. For the 41. Sarah? It is clear that such evidence are not normally is required to be allowed to produce at the appended stage and only on certain conditions, comma, an exception is to be made out. Para. In the instant case, comma, the evidence have to be adduced does not appear to fall within the exception made out in order 41 rule 27. A, comma, double A and B. Side over. Para. In view of the above, comma, this court is of the opinion that no case for interference is made out, and accordingly, this petition stands dismissed. And I got to line to. This court has also noticed that the information gathered by the petitioner where could have been produced, could have been proved before the state officer, isn't it? The state officer at the stage when such proceeding was initiated. And that not having been done, comma, there is no scope for application of order 41 rule 27.
Same order.
Same.
Lordship, I have prepared made in the morning by my junior. Item number 45, it can be taken before your lordship rises. The
40?
emergency is there because the matter is fixed before the arbitrator
We
tomorrow.
cannot pursue. We will pass a judgment at today we exceed at 2:10. You have to meet 2:10. Let us see, we'll try. This matters cannot be said to have a general application. It will depend on the evidence which is not to be adduced. So it's not a clearly covered case. Maybe facts are almost similar, so you can say otherwise each fact needs to be appreciated.
Lordship.
Part 3, case after learned conflict for the petitioner. Whereas the respondent is represented by Sri S. Ali. Considering the subject matter and as agreed to by the learned counsel for the parties, comma, this petition is taken up for disposal at the motion stage itself. Full stop. Para. The petition has been filed under Article 227 of the Constitution of India in respect of an order dated 7/7/2023 passed by the learned civil judge, Darang, in title execution case number 5 of 2018, whereby the petition number 1591 dated 22/6/2023 filed by the decree holder under order 21 rule 35 within bracket 3 where it section 151 of the CPC has been allowed. Full stop. The fact projected in the petition is that a title suit was executed by the elder brother of the present petitioner, who was the defendant, being title suit number 15 of 1996. Full stop. The state suit was for a declaration of right, title, interest, recovery, and injunction. Full stop. The state suit was decreed in favor of the plaintiff, and the state decree was upheld in appeal. Full stop. The issue which has been sought to be raised as per the present petitioner is with regard to identification of a particular part of the suit land. Full stop. Attention of this court has been drawn to a report of the circle officer dated 17/3/2023 and another report of the Lat Mandan dated 5/3/2023 with regard to a structure measuring 16 into 10 feet with tin roof having wooden posts and pakka floor. And as per the aforesaid two report, such a structure was not found existing, not found to be existing. Full stop. It is submitted that on 13/2/2023, the writ was issued full stop. The Sapta Learned Counsel for the petitioner has referred to the petition of the decree holder and has specifically drawn the attention of this court to the prayer made in the state petition. Full stop. The learned counsel for the petitioner submits that he is not opposed to execution of the decree, but his interest is only with regard to such execution being done after proper identification of the property, land and property in question. Full stop. He submits that the impugned order dated 7/7/2023 has been passed without granting proper opportunity and without taking into consideration the relevant material. Full stop. It is accordingly prayed that necessary interference be made with the state order dated 7/7/2023. Full stop. Per contra, Sri S. Ali, the learned counsel for the respondent, has submitted at the outset that the present attempt of filing this petition lacks bona fide, as the suit which was instituted in the year 1996 is yet to be, as the plaintiff who has successfully instituted the suit in the year 1996 is yet to get the fruit of the decree passed in the suit. Full stop. He submits that the present petitioner who was unsuccessful in the trial court, first appellate court, second appellate court, and even in the Honorable Supreme Court. And thereafter, the present attempt has been made only to cause further delay. Full stop. He has also informed this court that on an earlier occasion, a petition under a revision petition was filed in this court, which was also dismissed. Full stop. Sarah. Replying on the merits of the case, comma, Priali, the learned counsel has submitted that there is no confusion at all with regard to the land in question, as the same is covered by boundary walls. Full stop. By drawing the attention of this court to Schedule 5, Roman 5, which also contains a sketch map of the land in question, comma, it is submitted that the total area of the land is 1 bigha, 2 katha, 10 letter, and as per a family arrangement, comma, 2 katha, 10 letter, it was given to the defendant. Full stop. He has submitted that the entire plot is covered by the point A, B, C, and D, out of which the portion of 2 katha, 10 letter given to the defendant is covered by points E, B, C, and F. Full stop. He submits that since the defendant did not have a dwelling house, comma, in the portion of the land belonging to the plaintiff, comma, a temporary structure of 16 feet by 10 feet was allowed to be constructed, wherein the defendant was allowed to reside. Full stop. The learned counsel clarifies that in course of his profession, comma, the petitioner used to reside at Guwahati most of the time. Full stop. He submits that the suit, which was instituted in the year 1996, had culminated in the decree, which was also affirmed by the highest court as submitted above, as observed above, and even after 29 years of such institution, comma, the fruits of the decree is yet to be enjoyed by the plaintiff. Full stop. Sarah. Priali further submit that in the written statement filed by the present petitioner as defendant, comma, there was no denial at all with the aforesaid fact of existence of a temporary structure as mentioned above in the portion of the land covered by points A, E, F, D, measuring 1 bigha belonging to the petition. Full stop. He accordingly submits that the present petition is an abuse of the process with the intention to further delay the matter. Full stop. Sarah. In support of his submission, comma, Priali, the learned counsel, has relied upon the following decisions. Para. Sri Ali, the learned counsel, has finally submitted that there being no dispute with regard to the identification of the land which was bounded by brick walls, and there being no denial in the written statement regarding existence of the house in Schedule 5 of the plain, there is absolutely no instance made out requiring any interference with the order passed, order dated 7/7/2023. Full stop. It is by citing the aforesaid case clause, it is submitted that any change brought in pendente light or even after passing of the decree is not required to be challenged in a separate suit, and the executing court has adequate powers to execute the decree in its letter and spirit. Full stop. Para. Rejoining his submission, Sri Sattar, the learned counsel for the petitioner, has drawn the attention of this court to a reply dated 10/1/2022 obtained under the Right to Information Act regarding the house in question. Full stop. Para. The rival submission made by the learned counsel for the parties have been duly considered, and the materials before this court have been carefully examined. Full stop. The suit which was executed in the year 1996 and was decreed in favor of the plaintiff had attained its finality, as all appeals, including one before the Honorable Supreme Court, referred by the defendant, have been dismissed. Full stop. Schedule 5 of the plaint, which has been reproduced in the decree, clearly clearly reflects that out of a total area of 1 bigha 2 kata 10 letter covered by points A, B, C, and D, an area of 2 kata 10 letter carved out of the total area and covered by point E, B, C, and F was given to the defendant, and thereby an area of 1 bigha was retained by the plaintiff respondent. Full stop. The fact that the temporary structure of 16 into 10 feet was existing within the point A, E, F, and D has not been disputed by the petitioner. Full stop. So, Sri Sattar, the learned counsel for the petitioner, has submitted that the impugned order was passed on 7/7/2023 without affording an opportunity of filing objections, on a specific query made by this court with regard to any such pleading to the effect that the present structure is not existing within the point A, E, F, and D, nothing could be shown from the present petition. Full stop. For better understanding, the sketch of the land involved is expected herein below. Below, huh? Is 150. Full stop. This court has also noticed that the description of the house from which the defendant was not to be evicted, as mentioned in Schedule 5, has not been denied in the written statement or at any subsequent stage. Full stop. Under those facts and circumstances, this court is of the opinion that the order dated 7/7/23 impugned in this proceeding does not suffer from any infirmity which calls for interference by this court. Full stop. In any event, the power to be exercised by this court, by the powers of revision to be exercised by this court is circumscribed and is dependent upon certain conditions which are broadly given as follows from our perspective. This court is also guided by the law later by the Honorable Supreme Court, more particularly the case reported, Supreme Court, that the executing court can exercise incidental powers and remove any structure made pendantly light to execute the decree in its letter and spirit. Full stop. This court is also of the view that the information which has been sought to be obtained long after the decree was passed under the Right to Information Act would not be relevant in the execution of in the adjudication of the present lease. Full stop. In view of the above, this court is of the unhesitant opinion that the instant petition is devoid of merit and accordingly the same is this.
Lordship, may I have one thing there is the item number 21, Your Lordship. Item number 20 is, I am there, Your Lordship. I have some personal.
That also needs to be dismissed.
Item 21.
That also needs to be dismissed over. But that you are the petitioner.
I am petitioner, Your Lordship.
You will not dismiss.
It may be taken up coming Friday, Your Lordship.
Whenever. It is at the motion stage. Whenever, this Friday. On request, this one. That will be, I think, fourth. Yes.
The impugned order is that page 32, Lordship. Lordship has already
32.
yes. And WSL is also ready, Lordship. Open PPR
Impugned order is not at 32, 33,
33, Lordship.
6/7.
Yes, Lordship. So next date is fixed on 7/8, Lordship.
What is your case?
My case is, Lordship, the processing has been, divorce proceeding has been instituted in the family court, and thereafter, Lordship, counseling proceeded. And she was given one chance, Lordship, and 5/4 date was fixed for filing WS. On that day, adjournment was taken, and that was allowed. And subsequently, on 6/7, another second date was there, Lordship. So Lordship, WS was not ready
Heard.
by that.
MSP Stone, learned counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India, challenging an order dated 6/7/2023, passed in FC Civil case number 247/2022 by the learned principal judge number 2, Roman 2, Kamrup M, whereby the scope of filing written statement by the petitioner, who was the respondent, has been closed. Full stop. The petitioner is the wife against whom a proceeding of divorce has been instituted by the respondent as first party. Full stop. It is submitted that since the matter was at the stage of conciliation, the petitioner was under the bona fide impression that the time for filing written statement would not be reckoned during such period. Issue notice returnable on, when is the next date?
7/8 is the next date, Lordship.
Returnable on 25th of August 2023. Let steps be taken for service of notice upon the sole respondent by registered postal date. The parties, the petitioner is also at liberty to intimate the respondent oblique his counsel regarding the next day, regarding the present proceeding and the next day, as the case before the learned family court has been stated to be on 7/8/2020. The learned counsel prays for an interim order. Considering the facts and circumstances, this court is of the opinion that interest of justice should be served if further proceedings in FC Civil number pending in the court of is suspended. Accordingly, the aforesaid proceeding is suspended till the returnable date. It is however made clear that since on the appearance of the parties, this court would make an endeavor to dispose of the petition.
I'm deeply honored.
Take steps tomorrow by tomorrow. Thursday tomorrow. Thursday tomorrow.
This will be.
May it please your lordship.
Yes.
Lordship, I have come against the order dated 6/5/2023, whereby my right to file a written statement filed by me was not accepted on the ground that there is a delay of 24 days. Lordship, my contention is that when the suit was filed against me, the suit was filed on 21st of July, and thereafter the notice was served upon me on 27th of July. And thereafter, when I appeared before the court on 19th of November, on 23rd of September, the court itself fixed a date, that was 19th of November, to file that written statement, and I complied with that order. But however, when I filed the written statement, it was not accepted, not considering the fact that the court itself had fixed the time period beyond the 90 days time period for filing of that.
You should have presented it.
I presented the facts.
No, you should have presented the written statement. You did not file it in the court.
No, I filed it on 19th as per the direction.
You did not file it in the court. You should have filed it within the prescribed period of time in the office.
Your lordship, as per the order, if I may take you to the order dated,
We have understood.
Yes.
Court has fixed a date beyond 90 days.
yes.
Will it preclude you from filing the written statement prior to within the period of 90 days?
No, it was not precluded, but considering the fact that the court had itself
No,
fixed,
court-
so
We will go by the statute. Statute says 90 days. If
State-
the court fixes a date beyond 90 days, can you say that no, the court has
Yes.
given a date?
your lordship, if I may take
Is
you to,
the filing to do anything with the court proceeding?
your lordship, if I may take you to the judgment of this honorable high court. There is, if I may,
Yes. Yes.
your lordship, if I may take you to the paragraph number 11. If I may read the paragraph.
Eleven.
11.
Yes.
In the case in hand, the learned court below had itself allowed the defendants by its order dated 8/2/2010 to file written statement fixing 3/6/3/2010 as the date for filing of the written statement. The correctness of the order dated 8/2/2010 granting time to file written statement till 6/2010 was never questioned by the plaintiff opposite party. Therefore, in terms of the order dated 8/2/2010, the defendant could have filed the written statement on the date so fixed, that is 6/2010. No application under Section 5 of the Limitation Act was necessary for seeking condemnation or delay in filing the written statement.
Your name?
G.R. Datta.
Heard to hear Dr. Learned Counsel for the petitioner who has filed this application under Article 227 of the Constitution of India, challenging an order in 6/5/2023 passed by the learned civil judge number 1, filtered in PS number 134 of 2023, whereby the written statement filed by the petitioner, who was the defendant number 1, has not been accepted. Full stop. The reason cited for such non-acceptance is that the same was presented after a period of 90 days. For Saptara, the Senate Council has submitted that the date fixed for filing written statement was on 6/5/2023.
So on 19/11/2023.
On 19/11,
2022.
what was the date? On
Date-
19/11.
19/11/2020.
On 19/11, which itself was beyond the period of 90 days. And therefore, there was no occasion to reject, to decline acceptance of the written statement presented on the state date. The Learned Council has also relied upon a judgment of this court reported in which it has been held that while a court would have power, who can exercise discretion to accept a written statement beyond the prescribed period of 90 days, the same period being directed in nature as held by the Honorable Supreme Court in the cases of rejecting declining acceptance of a statement on a date fixed by the court, which is itself beyond the prescribed period, would not be justified. That is to notice.
Your Lordship, further proceedings.
Returnable on. What is the suit for?
Suit for recovery of compensation for 16 lakh rupees.
Returnable on
The next
on
date,
25th. What is the next date?
next date is on 20th of September 2020.
Early on 25th of today, not 25th, on 1st of September. Let steps be taken for service of notice upon the sole respondent by registered post with 80. Steps within 2 days. Para. The Learned Council prays for an interim order. Para. Considering the facts and circumstances and also the law laid down in the case of Supra, it is directed that further proceedings in case, title suit number in the Court of Civil Judge number 1 shall remain suspended. Correct? It is however observed that on the returnable date, this date, an endeavor will be made to dispose of the
Item number 16 is a similar matter in which I am the representative for the defendant number 2. So facts of the case are same, arising from the same title.
same case,
Same
same
case,
title suit.
same title.
You are a different number 2.
2. So different number.
Take care. Dates are same.
Dates are also same. Obliged.
We are giving same date.
May it please your Lordship.
Yes.
Lordship, the petitioner is a defendant in the suit. Notice was served on his manager. He instructed the manager to engage counsel. Counsel asked for some documents. Unfortunately, the petitioner's chartered accountant succumbed to COVID. So the documents were not readily available. After that, there was a communication gap between this council and the petitioner. The petitioner was residing in Delhi. He's a permanent resident of Delhi, but he has businesses in Assam. So there was, from records, it appears that the council he engaged took adjournments, but did not inform the petitioners of the same, did not even inform the petitioner that there is a time limit of 90 days, you have to file a written statement. So eventually there was a lack of information from ground. So his other set of lawyers visited the civil court and discovered that the suit, there's an order of the trial court ordering ex parte to proceed ex parte. So the very same day, we moved an application under Order 9 Rule 11 to set aside the ex parte stay with a condemnation of delay. The trial court holds that there is no sufficient cause and that it is not imaginable that there was a miscommunication or there was no communication between the council and the petitioners, and therefore refused to condone delay and held that our Order 913 is infructuous.
Order 9 Rule 13.
And therefore we are not allowed to present a written statement, and the suit is to proceed ex parte. And we've come in appeal against those orders. Would Lordship want to see the impugn orders?
You have not come in appeal.
Revision, sorry, revision, Your Lordship, yeah. Lordship, the impugn order is at page 45. And at 48 is the finding.
Yes, sir.
Lordship, this is the order in section 5 for condemnation of delay, because the ex parte order was on 1st November, but we only got to know on 2nd of February when we visit the court. And that very day we applied under Order 9 Rule 13.
How is the petition lie for revision?
Lordship?
This is an appealable order.
No, it's not an appealable order anymore. That's why I did petition.
Why?
Because.
Why not appealable order?
Huh? We are against the order. We are against the order where delay was refused to be condoned, against which a writ is maintainable. Order 9 Rule 13 was held to be infructuous because they refused to condone the delay. Lordship, may kindly take a
Under
look.
43 Rule 1D. Under 43 Rule 1D.
Lordship, no, Lordship, a writ is maintainable against an order which refuses to condone delay.
No, not read. You have come for a revision. There is an
Revision.
appeal is provided. Appeal is provided under 41. Come to 43 Rule 1D.
You want to do it? Various ones.
Order 43. Rule 1D. An order under or Rule 13, Order 9 rejecting an application.
Lordship, we've come prior to that. What has happened, Your Lordship? That's what I was trying to say.
No,
There were
you
two
said that-
applications.
You said that Section 5 has been dismissed.
Yes, Your Lordship. Because
Dismissal of-
after Section 5 has been dismissed, he didn't even go into the merits of Section Order 13.
It doesn't require. You read 2005 1 as this is.
Lordship, we keep it.
It is an order on merit. Appeal will lie. Shyam Sundar Sharma.
Lordship, because here, Lordship, kindly take a look at the impugn.
These are not matters of deliberation. These are all settled matters, right?
Lordship, the problem is he didn't get into the merits and he
Doesn't require. I'm not saying that you are remedialist. You file an appeal. We'll allow you to get your certified copy here.
ঠিক আছে,
from this. File an appeal.
আমি তো appeal file করবো।
If appeal is there, we cannot go for a revision. Third, MS G. Goswami, Learned Counsel for the petitioner who has preferred, who has filed this petition under Article 227 of the Constitution of India against an order dated 24/5/2023 passed by the Learned Court of Civil Judge number 1, Achar Silchar in Mid J case number 28 of 2022 in connection with Mid J case number 29 of 2022 in title suit number 113 of 2022. The petitioner was the defendant against whom under certain circumstances, an ex parte order was passed which the petitioner was not aware of. Ultimately, the petitioner had approached the Learned Court by filing an application under Order 9, Rule 13, along with an application under Section 5 of the Limitation Act to condone the delay. The state petition filed under Section 5 of the Limitation Act has been dismissed, resulting in consequential dismissal of the petition under Order 9, Rule 13. The Honorable Supreme Court in the case of Shyam Sundar Sharma versus Pannalal Singh, reported in 2005, 1 SCC has held that dismissal of an application under Section 5 of the Limitation Act would also mean a dismissal of the entire case, and therefore an appeal would lie full stop. In any case, in the case of Virud Nagar versus so-and-so, reported in so-and-so, the Honorable Supreme Court has further laid down a caveat that whenever there is remedy under the code COD, constitutional provisions are not liable to be invoked. At this stage, in view of the above, the present petition is held to be not maintainable. Not maintainable and therefore dismissed. Liberty is, however, granted to the petitioner to file an appeal if so advised. Further, to facilitate preferring of such appeal, registry is directed to return the certified copy if sought for by the petitioner.
Obliged.
May it please your lordship.
Yes.
My lord, the petitioners before your lordship, they entered into an agreement with the respondents in the year 2017, my lord, for sale of a particular flat, my lord. On the basis of that agreement, my lord, payments were made and the possession of the flat was also given. However,
You are the builder.
No, I am the purchaser, my lord.
You are the purchaser.
I am the purchaser. Amala, what happened?
1 second. Petitioner is the purchaser. You are the plaintiff.
I'm the, no, plaintiff is now, this is the second suit. First suit, my lord, the plaintiff, the petitioner before your lordship instituted a first suit for specific performance of contract and registration of sale deed.
1 second. No, here, so far as
Insofar this suit is concerned, my lord, this petition, my lord, the respondents were the plaintiff.
you are the defendant.
I am the defendant, my lord.
Petitioner defendant.
Petitioner defendant.
Now you are the purchaser.
I am the purchaser, my lord. My lord, that particular sale deed was executed in the year 2017. Agreement for sale, but agreement for sale was executed. And after
agreement for sale,
lordship,
it's a flat or what?
it's a flat. My lord, the money was also transferred into the account, my lord, through
bank transfer and checks, my lord. Possession was also handed over.
Now
And
what is the problem?
Lordship, thereafter, in the year 2020, my lord, the respondents as plaintiff filed a suit. My lord, the prayer made in the suit, Lordship will find in page 37, my lord.
Suit for?
Suit was for, my lord, cancellation of the sale deed, my lord, agreement for sale. If your lordship peruses page 37 is the prayer portion of the plaint, my lord.
But you said that the agreement was already executed.
Agreement, my lord.
Money transfer, position handed over.
Possession was handed over. Then, my lord, we filed a suit before the trial, civil judge one, that for specific performance for registration of the sale deed, my lord. In that, after institution of our suit, my lord, the defendants in the suit as plaintiffs have instituted a second suit in civil judge number 2, my lord, before civil judge number 2. And this second suit is the subject matter before your lordship today, my lord.
Now what is the difficulty here?
My lord, the prayers made were, my lord.
No, what is your prayer here?
My lord, the amendment has been allowed after, my lord, the initiation of the trial, my lord.
Which amendment?
My lord, yes, lordship. The petitioners filed, the plaintiffs, they filed a application under order 6 rule 7 for, my lord, amendment of the plaint, my lord. And that amendment petition itself was filed at the stage when the trial of the suit has already commenced.
What was the stage?
My lord, SBPA stage has already started. My lord, we had taken steps for calling for certain documents. And my lord,
Evidence has not started.
my lord, but the issues were framed, my lord. My lord, my lord, there are Supreme Court decisions.
Supreme Court decision decided that side both.
My lord, may I just place 2 judgments, my lord?
Come to 670.
My lord, one is, my lord, 2009.
No, first let us come to 670. What is 670?
Yes, lordship, certainly. Amendment of pleadings, lordship, may I just read out, my lord?
Yes, please.
The court may at any stage of the proceedings allow either party to alter or amend his pleadings in such manner or on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties, provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. This was not there, my lord. The agreement was executed way back in 2017. They filed the suit, and thereafter,
When was their suit executed, instituted?
my lord, suit was instituted in the year 2020, my lord, as part of verification and the plaint, my lord. On page 39, my lord, on 23rd of June, my lord. 23rd of June, 2020.
SBPH case.
Lordship,
Is the state of SBPH.
it is in the stage of SBPH, my lord. That itself is reflected in the order, my lord, and issues have been framed. my lord.
Yeah, 617 have been explained that it can be at any stage of the proceeding, number one.
Lordship,
Number two, there is a caveat that after the trial has begun, normally not. But then also the court has been given discretionary powers that unless the court comes to a conclusion that despite of due diligence.
Lordship,
Three conditions.
true, my lord.
Now, SBPH, will it mean commencement of the trial?
My lord, this was just an attempt to fill up the lacuna and the negligence of the plaintiff. This cannot be allowed, my lord. My lord, the plaintiffs,
What is the amendment sought for?
my lord, amendment sought for, lordship will find the prayer for amendment, the
Will
relevant.
it change the nature and character of the suit?
Lordship, certainly, my lord. Page, lordship will,
The
find,
their suit was for cancellation of the agreement, is it?
agreement.
Now, what is the amendment sought for?
My lord, lordship will find in their application, my lord,
Yes.
page 74, my lord.
Yes.
Page 75, rather, my lord. 75.
Yes.
It starts from in 74, they, in a long paragraph, they explain.
Yes.
And it ends with the word follows, my lord, page 74. That follows means that the following amendments. That in third line of para 5 of the plate, after word defendant, word, the word number 1 may be corrected as a this is okay, my lord. B, that in first line of paragraph 6 of the plain, the word defendant may be corrected as plaintiff. This is also no. That in the last part of para 6 of the plain, the following sentences may be added. It is stated that in the at the time of execution of the said agreement for sale number 2005/2017, the plaintiff number 2 was at Mumbai, that is in his permanent residence at Cosmos apartment flat so and so, Crossroad, Lokhandwala complex, Mumbai. In fact, in the year 2017, the plaintiff number 2 came to Guwahati only once on 28/4/2017, Indigo Airlines, and returned on 15/5/2017. Therefore, the question of execution of the said agreement for sale number so and so on 31/2017 at Guwahati and appearance before the sub-register Kamrup on 18/3/17 for registration of the said agreement cannot even imagine. It is stated that the signatures appearing on the undisputed registered sale deed dated 18/7/16 and the agreement for sale dated 16/8/18 and the signatures appearing on the agreement for sale number so and so dated so and so itself crystallized forgery acts of defendant number 1, 2, 3 with respect to the suit property. Now, my lord, 3 is their own manager. My lord, even in the principles of vicarious liability, my lord, the principal is a manager executes everything, my lord, hands over the position, and now he is accusing the own agent, my lord. Moreover, from the said agreement of sale, my lord, these are there. And then they want to, my lord, more important is they want to now substitute and add another prayer. Although in the main suit, they have made a prayer for compensation, my lord. Now there will be overlapping of prayers also. Well, this is nothing but they are filling up their lacunas now once the trial has commenced, my lord.
Let us see the appeal order.
Lordship. It starts from page 91, my lord. Shall I read, my lord?
Yes.
Parties are represented. Today is fixed for passing order on petition number so and so under order 6 rule 17 read with section 151 CPC. By the petition, it is stated that the petitioners oblique plaintiffs preferred the suit for declaration, cancellation of agreement for sale dated 31/17, recovery of khas possession, compensation, etc. against the defendants. Further, it is stated that they filed the suit very hurriedly during the COVID-19 pandemic. And this is important because COVID-19 pandemic, they might have filed, but the amendment application was filed in the year 2022, my lord. Much after that, my lord. If they had realized that they would have filed it earlier, my lord. Once after commencement of the trial, my lord. That plaintiff number 2 is the managing director of the plaintiff number 1 company, resides in Mumbai, and due to COVID-19 pandemic, the plaintiff number 2, being a senior citizen, was compelled to keep himself away from normal life. As such, at the time of filing of the suit, some vital facts were left out in the plain, and also some typographical mistakes were occurred in the plain. Hence, the instant petition has been filed for amendment of the plain by incorporating the vital facts which are mentioned in para 2A, B, and C in the petition. Subsequent to the amendment of pleadings in the prayer portion, one new prayer after prayer number 5 is to be incorporated. If your lordship peruses prayer number 5, it is already for payment of compensation, my lord. Now again, they are asking for rent, my lord, which is reflected in para 2D of the petition for amendment. It is submitted that the suit is very early stage and therefore it is evident for allowing this application at this stage. The opposite party defendants will not suffer in any way as they will get ample opportunity to rebut the fact, etc. Therefore, the prayer has been made to allow the application for the interest of justice. Learned counsel for the opposite party have filed written objections stating that the application filed by the plaintiff praying for amendment of the plain does not merit any consideration at the hands of this court, as the petition itself is not only contrary to the provisions of law, but the same is an afterthought of the plaintiffs to improve upon their case pursuant to the framing of the issues. Therefore, the application for amendment is liable to be dismissed in limine. It is further stated that the application for amendment filed by the plaintiffs as a counterblast to the application filed by the defendant
number 1 and 2 under order 11 rule 1416 of the CPC, because we asked for certain documents, my lord. Thereafter these things came, my lord. The registered deed were in their position. When we filed an application for production of the registered deed, then they filed this amendment application, my lord. That the proposed amendment is completely unnecessary for deciding the real questions of controversy involved in the suit, but an ulterior motive for the purpose of delaying the disposal of the suit. That the reliefs which the plaintiff is seeking by means of the proposed amendment cannot be granted in the suit, and therefore there can be no question of the proposed amendment being necessary for adjudicating the matter in controversy. The amendments sought for are wholly unwarranted, and the same ought not to be allowed, since the trial has already commenced in the suit after framing of the issues and the defendants having taken steps under order 11 rule 14 and 16 of CPC. Therefore, the prayer has been made to dismiss the application for amendment of plaint filed by the plaintiffs with exemplary cost. I have already heard the learned counsel of both the parties peruse the case record. Perusal of the record revealed that the suit was filed by the plaintiff for cancellation of agreement dated 30/1/2017. The record further reveals that the case has proceeded up to the stage of SBPX. And on that stage, petition for amendment has been filed. On perusal of the amendment petition, it is seen that there are typographical mistakes in third line of the paragraph 5, as well as in the first line of paragraph 6 of the plaint, as mentioned in paragraph 2A and 2B of the amendment application. Further, from the prior portion of the plaint, it is found that the plaintiff has filed a suit for cancellation of the agreement on the ground of fraud. Now, my lord, this particular rule order which has been quoted is order 6 rule 4 is incumbent at the time of filing of the plaint while drafting the plaint, my lord. This does not empower them to fill up their lacuna and negligence, my lord. In all cases, order 6 rule 4, in all cases in which a party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other cases in which the particulars may be necessary bound, such are exemplified in the forms aforesaid, particulars with dates items necessary shall be stated in the pleadings. They missed to state all these things. Now, after commencement of the trial, I respectfully submit, my lord, and that too when we have sought for from the amendment sought to be incorporated in the last part of paragraph 6 of the plaint, it is found that those contentions are necessary to be incorporated in the plaint as the plaintiff's pleadings are based on fraud. That being so, the proposed amendment as mentioned in paragraph 2C of the amendment petition is found necessary to be incorporated, and the same are necessary for the purpose of determining the real question of controversy between the parties. Consequent to which the amendment sought in the prior portion is also allowed. Hence, the interest for the interest of fair adjudication of the matter, the amendment is allowed. However, a cost of rupees 2,000 is to, but court has imposed only 2,000 rupees, my lord. Ultimately, court was also prima facie convinced that this is not the proper stage, my lord, to bring an amendment. And this order 6 rule 4, which is the primary reason, this calls for due diligence at the time of preparing the plaint, my lord. And the prayers are overlapping. May I just, lordship, for once again take your lordship to that prayer portion, my lord, page 38, my lord, page 38. The prayer was already there for compensation of 5 lakhs, my lord. And this cannot be a case of hurriedly filing of plaint. The agreement was executed in 2017. Even the question of limitation will also come into play now. On 31/2017, the agreement was the disputed agreement was executed, and in in June 2020, the suit is instituted. Even taking account that relaxation given by the Honorable Apex Court or during the COVID period, that will also might not help them. Of course, that question will be left open for the trial court. And there is no breakup of the amount, my lord. How they have computed this 23,500, my lord? On what basis?
Those returns are married. I'm merely stating that on an amended petition, it doesn't mean that it is established. Some rebuttal, they have to prove it in accordance with law. You can cross-examine.
True, my lord, but again, this again, an amounts overlapping, my lord.
So what is the prejudice you are going to suffer? There is no certain
definite change in the character and nature. It is the stage of SVP.
My lord, when we file an application for production of that agreement, for sale,
That may not be the.
that certified copy.
See, there, if the law entitles them to file an application, the timing of the application may not be very relevant for us.
But the law states that that is why the law takes care of that before trial, these things should be brought.
That is it, SVP.
Because
Do you have any decision?
My lord,
Do you have this, what do you mean by it?
my lord, in what manner I will lay my evidence will
Now, what
depend on
is
the
the meaning,
issues.
what is the meaning of trial, commencement of trial?
My lord, as per the Supreme Court decisions which I have understood, my lord, it's clearly says from the stage of my lord framing of issues, my lord. My lord, I may just raise.
Where the issues framed? In this?
My lord, issues were framed much prior to this, my lord. The date I have quoted in my petition, my lord.
There are many decisions. What is the citation you are trying to?
My lord, on 21/1/2020.
What is the citation you are relying upon?
My lord, one is, my lord, 2009 2 SCC page 409 by Honorable Justice S.B. Sinha.
2009.
2009 2 SCC page 409.
What is the name?
My lord, Vidya Bhai and others versus Padmalatha and another. In paragraph 11, my lord.
Have you given one is Kailash Kanpur? Yes, Vidya Bhai.
In paragraph 11, if your lordship peruses.
Yes.
My lord, paragraph 11, I'm just reading out, my lord. From the order passed by the learned trial judge, it is evident that the respondents had not been able to fulfill the said precondition. This is something else. The question, therefore, which arises for consideration is to whether the trial had commenced or not. In our opinion, it did. The date on which the issues are framed is the date of first hearing. And the CPC also says talks about, my lord, that order 6 rule 17 talks about hearing, my lord. Provisions of.
And you see.
And my lord, the same analogy is, my lord.
Commencement of proceeding. See, commencement of proceeding. First hearing is a different meaning. Read further.
Provisions of the Code of Civil Procedure envisages taking of various steps at different stages of the proceeding. Filing of an affidavit in lieu of examination of the witness, in our opinion, would amount to commencement. This is, my lord, in the order 6 rule 17, it talks about hearing stage, my lord.
Let us see again.
Yes, lordship.
What is the expression used?
The terminology used is hearing, my lord. The trial, my lord, commencement of trial, my lord.
Okay.
Trial, my lord, trial.
Oh, hearing is
trial. But in Kailash versus Nanku, my lord, it has been held, another decision which I have placed, my lord.
That was in the context of
but election petition, but it talks about the civil case also, my lord.
No, that was in the context of the directory and mandatory nature of a prescribed period in the written statement.
My lord, but when the trial commences, that has been decided, my lord. May I just indicate that particular paragraph to your lordship, my lord. In Kailash versus Nanku, my lord, the citation which I have placed, my lord, yeah. In paragraph 13, if your lordship takes up.
Yeah. Yes.
At this point, the question arises, when does the trial of an election petition commences, or what is the meaning to be assigned to the word trial in the context of election petition? Then it is held. In a civil suit, the trial begins when issues are framed and the case is set down for recording of evidence. My lord, the case was set down for recording of evidence. That is why we sought for certain documents which were not available with us.
Will you read the next paragraph?
all the proceedings
Read the
before the
next paragraph.
stays are treated as proceedings.
14.
My lord.
Harish Chandra Bajpai.
In Harishchandra Bajpai Tiloki Singh, the narrow and wider sense of the word trial is used, came up for consideration of the court. It is narrow or
In
limited
its
sense.
narrow, in it.
In its narrow or limited sense, trial means the final hearing of the petition consisting of examination of witnesses, filing of documents and addressing arguments. In its wider sense, the word trial indicates the entire proceeding from the time when the petition comes before the court until the pronouncement of decision. In the context of an election petition, it was held that the word trial must necessarily include matters preliminary to the hearing, such as settlement of issues, issuance of directions, and like. With the receipt of the petition in the High Court, various steps have to be taken before the stage can be set for hearing it. The respondent has to file his written statement and the issues have to be settled. The stages of discovery and inspection, enforcing the attendance of witness, and compelling the production of the documents do not form part of hearing in a trial governed by CPC but preceded. The purpose of election then. Finally, this is also in the context, the last sentence, my lord, of paragraph. It is held that a hearing of an application under Order 6 Rule 17 for amendment of pleadings would be at the stage of trial of an election. That is of course in the realm of election petition, my lord. So, my lord, in both the decisions, one thing is clear, my lord. The trial starts, my lord, once the issues are framed and the parties prepare themselves for laying down the evidence, my lord. And
Which date issues were framed?
my lord, on 21/1/2022. In my ground number 1, I
2022.
22, my lord. Thereafter, my lord, we filed an application. Of course, unfortunately, that is not from 9. Taking documents. On 7/2/2022, my lord, we filed an application under Order 11, Rule 14 and 16, which has been noted by the court below, of course.
Heard the G. Rahul, learned counsel for the petitioners who by means of this petition under Article 227 of the Constitution of India has put to challenge an order dated 12/7/2023 passed by the learned civil judge number 2, Kamrup Silo, in me case number 2, arising out of title number 2, put by the state order, comma, the application filed by the respondent as plaintiff for amendment under Order 6 Rule 17 CP has been allowed. Full stop. The learned counsel has submitted that there are rival titles filed by the parties and whereas the petitioner has filed a suit for specific performance of a contract and also for a direction for registration of a sale deed, comma, the rival party has filed a suit for cancellation of the agreement. Full stop. In the suit filed for cancellation of the agreement, comma, it is submitted by Sri Rahul, the learned counsel, that on 21/1/2022, issues have been framed, whereafter the application under Order 6 Rule 17 CP has been filed for bringing in certain amendments the Learned Council has submitted that so far as the amendment sought for making typographical error in paragraph 5 and paragraph 6 of the plain are concerned, he may not have any objection. However, he submits that the addition which is thought to be made after paragraph 6 and also regarding the new prayer number 5, he submits that there are serious objections to the same and it would be against the provision of law of Order 6 Rule 17 regarding 17 of CPC regarding amendment of reading. Full stop. To contend that framing of issues, content at the stage of framing of issues would mean commencement of trial, and therefore the embargo of the aforesaid provision of law would apply, the Learned Council has relied upon the case of Vidya Bhai versus Swain, reported in 2009, 2 SCC 409, issue notice returnable by 4 weeks. That tells for service of notice be taken by registered post of QITD steps by tomorrow. Learned Council for the petitioners praise for an interim order. After hearing and also taking into account the case law relied upon by the Learned Council for the petitioner, it is directed as further proceeding that the impute order dated there are 12/7/2020 passed into by shall remain suspended and consequently, the proceeding may be kept in abeyance by the Learned Court of Para. This court is, however, of the view that the matter is required to be disposed of expeditiously, and therefore it is observed that on the appearance of the parties an effort will be made to dispose of let the next date be fixed on place this case on first of September, Friday.
Bless you. Can it be on second, my lord?
Second is Saturday.
Then, my lord, any other date, my lord, then first, second.
Third is Sunday, fourth is holiday,
Holiday,
fifth is holiday,
seventh
sixth is holiday.
Eighth, my lord, then eighth Friday.
All holiday.
Eighth, my lord, it will be
Eight,
Friday.
ninth.
Ninth is Saturday again, my lord.
Oh, eighth.
Eighth, my lord. God bless.
Yeah. Oh, nice. Person, consequence. Mr. Ganguly? Yes, madam.
Lordship. This is item number 35, the direction for personal appearance, and I'm for the respondent.
Yes, why wasn't he appearing?
The earlier council have withdrawn the matter and I'm the newly engaged. This is my first appearance. I'll file the Okalnama.
But there is a non-compliance of the order. Personal appearance is only for the purpose that he has not complied with the order. Have you explained him the consequence of non-compliance?
Yes, I told him.
He may not be apprised with the provisions of law. Otherwise, you would have directly interacted with him. You advise your client, since he has come, that he needs to act in accordance with law. We may give you time to file written objection to the contempt petition. But prior facie, there is an instance of non-compliance, and he was deliberately avoiding
And
common.
Lord, the earlier council has withdrawn the Okalnama on 12/4. Continue, and this is my first appearance.
Okay, you file your Okalnama.
Sure.
What is your client's name?
Babul Gogoi.
Huh?
Babul Gogoi.
Abul Gogoi. Pursuant to the order dated 19/7/2023. Comma. Sri Babul Gogoi, the respondent, has appeared in person along with his counsel. What is your name?
D. Borua.
D. Borua. This court has been apprised that there was a communication gap with the earlier counsel appearing for him, who had withdrawn, and therefore he could not appear. I must D. Borua, the learned counsel, submit that affidavit in opposition to be filed in the contempt case, for which he prays for how much time?
3 weeks.
3 weeks time. That such affidavit in opposition be filed within a period of 3 weeks. Personal appearance of the Babul Gogoi is dispensed with for the present. তেখেতৰ লগত আপুনি আলোচনা কৰিব আৰু কোৰ্টৰ অৱমাননা নকৰিব। কি ক'ব লগা আছে তেখেতৰ হাতোৱে ক'ব।
May I please your lordship, my lord?
Yes.
My lord, I am challenging the order, my lord, where a third party interest have been allowed as an impleaded party in my probate proceeding, my lord. Where the father dies, the state leaving behind a will in favor of 2 beneficiaries of a daughter, and the attesting witness is the mother.
You are the daughter.
I am the daughter before your lordship, my lord.
There are 2 petitioners. Both are daughters.
Both are daughters.
Daughters.
Who had filed probate.
Will by father.
Who had filed probate.
Will by father. Will by the father.
Or will by the father, my lord.
And mother is the attesting witness.
Mother is the attesting witness, my lord. Testator is the father.
There you file for probate.
Probate.
Thereafter,
my lord, at the stage of evidence, one petition has been filed by a party who happened to be a widow lady, that means a daughter-in-law of the testator.
You had a brother?
Yes, who died, brother, elder brother, who died early.
Okay, he had married.
He had married.
That widow has come.
That widow has come at the stage of my evidence in the probate proceeding.
That means he is the daughter-in-law of the testator.
Testator.
Yes.
Now, my lord, the order is here. I have annexed which is challenged in page 42, my lord.
Yes.
Now, my lord, here the whole order makes only the reflection of being a daughter-in-law. Whether a daughter-in-law who has not been made share over the will which is being registered by the testator can be impleaded or allowed to be impleaded under Order 1, Rule 10 of the CPC before the proceeding of which is called testamentary succession proceeding, my lord. Where in that testamentary succession proceeding, where the will itself has to be proved by the said court, whether the will is genuine, whether it is been made by the full,
yes,
that thing, my lord. And the beneficiary is two daughters. And nobody can guide because it is self-acquired property. Now, my lord, she came before the Honorable Court and filed under Order 1, Rule 10 that she wanted to be impleaded, and the Honorable Court made her party in the proceeding, and that is an agreed. And according to that, this 227 petition before your lordship. Now, may I take your lordship to the page? Yes, page 43, my lord.
Yes.
The down portion above then the heard of the learned counsel of both shall, the above paragraph, my lord.
Yes.
Now, my lord, may I take your lordship, my lord? Said Anantaram Deka, your lordship got it, on State Anantaram Deka on 18/1/20.
Your yes, yes. You got it. Yes.
No, my lord. State Anantaram Deka on 18/1/20 on his free will and wish has executed a registered will in favor of the opposite party being daughters of late Anantaram Deka. It is also contended that the present applicant has lodged Azahar at Nunmati police station and filed domestic violence case against Anantaram Deka and Dimbesuri Deka, and the same is pending in the court landed Munshi 4, Guwahati. Late Anantaram Deka, while bequeathing the self-acquired property by executing will, had not mentioned any share for applicant who intend to get implemented in the probate proceeding. Hence, the petition of applicant is liable to be rejected. Later on, my lord, learned counsel for the applicant submit that the husband of applicant, namely Rajiv Deka, is only son of late Anantaram Deka and Dimbesuri Deka, and as such, the applicant is the necessary part in probate proceeding, without whose presence said proceeding cannot be decided completely and effectively. Hence, pray for allowing the prayer of application. Countering the submission of counsel for the applicant, learned engaged counsel of police party submit that the will in question has made in respect of self-acquired property of Anantaram Deka, and in the free will of testator, he had executed the will and thereby bequeathed his property to the opposite party, and as such, the applicant has no locus standi to file the instant petition with a prayer for arraying herself as a respondent in the probate proceeding. Hence, the prayer for rejecting the prayer. Considering the rival submission and counsel for both parties, sides, the perusal of factual metrics of the case, it is undisputed fact that the applicant is the wife of predeceased son of testator Antaram Dekar, so the applicant is legal heir through the predecessor son of the testator. On that view of the matter, he has a right to being heard in respect of property left behind by her father-in-law. So this is the facts. So when in the Hindu Succession Act, when a will is registered, then it is governed under Indian Succession 1925. When it is not been registered, then intestate succession is governed by the Hindu Succession 1956, where deceased do not leave behind a will. These are the two acts. Now, my lord, here, my lord, the party who has been allowed as an implicate must show before the honorable court that she must have equitable, cabitable right. Cabitable right. Now,
Are you disputing that she is not the daughter-in-law of Anantaram?
yes, my lord.
She is not the daughter-in-law.
No, she is daughter-in-law.
Yeah.
In a testament proceeding, where a near dear one can come a proceeding, can come in the right title interest, although he can come as a near dear one, come in the under 10.1. But there is also under order 1 rel 10.2, where striking out and adding of the party, where the honorable court has to be very cautious to enter the party and strike out the party. And that has not been considered by the trial court. And this is not a general suit. It is a suit of testamentary, my lord, where documents itself.
She is not entitled to challenge the
No.
of the will.
Yes. For that, my lord, may I take your lordship, my lord, to judgment, where it says in a testamentary suit, the implead of the party is not necessary.
Implead of which party?
Well, the third party who enters.
Who is the third party?
The third party is the daughter-in-law.
Here in that case, in your case in hand, which you are referring now.
My lord, I'm referring, my lord, 2008-4 SCC 300, my lord.
Who was the third party was thought to be?
My lord, your third party was, my lord, this is Krishna Kumar Birla, Rajendra Singh Lodha, my lord.
Who was the third party?
Here, my lord, Rajendra Singh Lodha was the third party, my lord.
We are not interested in the name. We are interested in the relationship.
Relationship.
Who was thought to be implicated? Who's the?
But a relationship will not come into play, my lord. The thing is that she must have a cabitable interest as an agnet, my lord, blood relation. Agnet comes into play again.
Daughter-in-law will not have any interest in the property.
No, my lord.
This is done.
No, my lord.
The Hindu Succession Act.
My lord, that will come into another play, my lord. This is only the probate case. In a probate proceeding, testamentary proceeding, only the will has to be seen because there is a limited.
This is at a very preliminary stage. Your attempt appears to be as if you are trying to foreclose somebody's right and preempt somebody's right at the beginning.
No, my lord, what the law
Only a
says.
hearing has been given, nothing has been said.
My lord, what the law says, I have brought before lordship, my lord, decision on what. That it says, according to that, I have come, my lord. Where may I read it?
Yes.
When we go through the dictum laid down by this judgment, it would see that all principles have been laid down in regular suit towards the implement of the parties. But it is a case of testamentary suit which has been dealt with the judgment of Honorable Apex Court reported in 2008-1. Kanwarjit Singh Dhillon, but Hardayal Singh Dhillon and others in 2007, 11 SCC, that is also you give. And also 357, 2008, 4 SCC, 300, Krishna Kumar Birla versus Rajendra Singh Lodha and others, in which it has been held. The question of title of trustees cannot be decided in a testamentary suit. If the question of the applicant is hit towards his implement, he would raise an objection regarding the title of tetratext that will be not be entitled in executing a will in respect. to have been belong to his mother only. The proposed objection would be in respect of title of tetratext. Therefore, the presence of applicant in the suit is neither necessary nor lawful in accordance with the judgment of the Emerald Court of the Honorable Apex Court cited above. To judgment, my lord. Only in general suit. Krishna Kumar Birla and Rajendra Singh Lodha and others. This will be the helpful for this for your lordship, my lord.
No, you have to emphasize to her that she doesn't have any interest in the property.
No, my
She is
lord.
not in a
She
position-
must have caveatable.
What is caveatable?
Well, yes, it is. I'm coming, my lord. What
the
is
meaning of
caveatable?
right?
Caveatable right means she must have, it is here itself in the Krishna Kumar Birla and others, my lord.
What is caveatable right?
Yes, my lord. It is here. Answer has been made, my lord. The caveatable interest means that means may I take your lordship, my lord? Yes, my lord.
Come to section 284.
Yes, my lord. That is for your lordship, my lord. Your lordship wanted to query the caveatable interest, my lord.
Yes.
May I take your lordship 330 page, my lord? 330, my lord.
You have seen that. Daughter-in-law will not have caveatable interest.
Well, she must show it, my lord, in her petition.
Daughter-in-law has to show her interest. The mere fact that it says daughter-in-law of a predeceassor's son.
No, my lord.
Is it enough?
No, your lordship wanted to query, my lord, what is the caveatable
No,
interest?
are you disputing that this party is not the daughter-in-law of your father?
My lord, that has not been made clear here, or it has not. It has
Are
been
you
made.
disputing? It will not be made clear by the court. It will be your stand. Are you disputing that the party which
When already it has been made a party, my lord,
Are you-
stating the fact that she is a daughter-in-law and other proceedings are also been pending, my lord.
That we were asking a question, you are not answering.
Yes, my lord, I am answering, my
What
lord.
is the answer? We are asking whether this party which has been implicated, are you disputing her relationship with the son of the
This is
deceased?
son of the.
This is your brother.
Yes, my lord.
Are you disputing?
No, I'm not disputing because the other cases are pending.
Don't waste our time.
Well,
Third, Triketi Chetri, Learned Counsel for the petitioners who by means of this petition filed under Article 227 of the Constitution of India has put to challenge an order dated 6/7/2023 passed by the learned Additional District Judge FPC number 3 Kamrup within bracket M 100 in Miss J case number 67 of 2020 arising in Miss Probate case number 38 of 2022. Full stop. Para. The facts projected by the petitioners who are sisters is that their father had executed a will by making them beneficiaries. Full stop. The said will was put to probate in the aforesaid case in which an application has been filed by the respondent under Order 1, Rule 10 for implement. Full stop. The learned court advised the order impugned dated 6/7/2023 has allowed the state's petition on contest. Para, the learned counsel for the petitioners has submitted that the will has been made in respect of self-acquired property of the deceased and with pre-consent, whereby the property in question has been bequeathed to the petitioners, and therefore the locus standi of the respondent has been questioned. Full stop. By submitting that before allowing such an application for implement, there has to be a caveatable right established, the learned counsel has relied upon the case of so and so, so and so. The contentions made have been duly considered. The order dated 6/7/2023, which is the subject matter of challenge, after taking into consideration the rival submission, has simply allowed the present respondent to be a party. Full stop. Such allowing the respondent to be a party will not mean that the prayer for grant of will would be per se rejected. And the only consideration is that before final orders are passed in the misprobate case, the present respondent would be given an opportunity of hearing. There is nothing on record to show that the respondent is the daughter-in-law of the deceased, whose and her husband so and so had predeceased. But there is nothing on record to nothing on record to show that there has been any objection to the assertion made that the respondent respondent is the daughter-in-law of the deceased, whose husband, who was the son of the deceased, had died earlier. Considering the efforts and facts and circumstances, this court is of the view that no infirmity has been able to be shown with the order, and therefore the instant petition is rejected. Yes.
Much obliged. My lord, predecessor of the respondent number one, my lord, she filed a suit, my lord, challenging a decree passed in favor of defendant 1 to 3, my lord, which was upheld in the appeal. Now, my lord, defendant number 1 and 2, my lord,
Just a minute, let me record.
my lord.
Who are you?
I am, my lord, the relinquished.
No. In the suit, your position, you are the
No, I am not in the suit, my lord, because the defendant number 3 was the attorney holder of defendant number 1 and 2.
In the suit.
Suit. And
defendant number 3 was
the attorney holder of defendant number 1 and 2.
Oh, defendant 1 and 2.
And defendant number 3 died, my lord.
3 died, okay.
3 died. But defendant number 1 and 2 also executed relinquishment deed in favor of the petitioners.
is favor of petitioner.
petitioners.
Okay.
Now, my lord, what happened after the death of the
Are you connected to the defendant?
my lord?
Are you related to the defendant?
No, my lord, my lord, I'm one of them, my lord, petition number one is the wife of the defendant number three, but two others are well, distant relation. Now, they filed a constituent petition, my lord, along with the son of my lord, the defendant number three, that there should be substitution, my lord, and they may be made parties. This petition is filed under Order 22, Rule 2, read with 151. Well, Order 1, Rule 10 has not been mentioned here because so far power is concerned, after his death, my lord, nothing remains. That finding is there. I'm not challenging to that extent because after death, my lord, power of attorney ceases, my lord. But so far relinquishment deed is concerned, my lord, we have filed a petition by three persons. The sons my lord, cannot be a party. The three petitioners, my
What
lord,
is your cause of action here?
my lord,
What's your cause of action?
no, because the defendant number three
No, what
died.
is your cause of action? Which order are you agreeing?
My lord, yes, I am coming.
Page 49.
Page 49, my lord.
49.
Page 49. This is the order, my lord. Who are the legal representatives so and so, whether right to survive in respect of living of disease number 3,
Well, 49.
49.
Both parties are represented. Today is Christmas so and so.
My
Our
lord.
peruse the materials on record.
Yes,
Perusal of petitions reveals that the state petition has been filed under Order 22.
my lord.
Rule 2.
Soma Mujumdar, praying for substitution.
You are someone there.
I am one Soma Mujumdar, my lord. Divakar Mujumdar is not there, my lord, because he is the son.
So for praying for substitution of names of heirs of. You are Soma.
I am Soma is also there and two others are there, my lord. Now this next page, page 50, my lord, this is the important, my lord. The second paragraph.
Just a minute. Who determined the potential who are the legal representative of our state for substitution?
Necessarily be implemented and substituted, my lord. This is we have said. The petitioner has stated. Yes.
That the wife and son of dead are the legal heirs.
My lord. The third para is important, my lord.
Soma and Dipankar are the two petitioners.
Yes, Dipankar, my lord, is not the prisoner. Because, my lord, in fact, I know, my lord, that after the
Our petition against it is a petition that
third para is important, petitioner.
two other individuals.
Petitioner stated that petition defendant number 1 and 2 execute a deed of relinquishment so and so in favor of Soma Mujumdar, Ranju Mujumdar, Sonali Mujumdar. They are the petitioners here. Therefore, it seems that petitioner are claiming that not only the wife of the deceased defendant number 3, but also Ranju Mujumdar and Sonali Mujumdar are also as the heirs and successor of defendant number 3.
I don't think your the procedure which you have adopted is correct.
My lord?
How can you come under Order 22?
No, not 22, my lord. Here we have mentioned 151. Order 1, Rule 10, we have not mentioned, but Order 1, Rule 10, 2, my lord, gives power to the court to
Pro moto even, but you could have
Yes.
invoked.
my lord.
Order 1, Rule 10
Yes,
will give the power to the court on its own motion. Court can on its own also impede or.
yes. When court finds, my lord, that there is a
But your
relinquishment.
case is totally different. You are claiming to be impeded on the strength of being
Relinquishment.
legal heir.
Relinquishment deed, my lord. Three
Or-
persons are, so far,
For relinquishment, you have to make a separate case.
my lord.
If you are banking upon the relinquishment deed,
Yes.
wherein two other persons come in, not
Yes.
only Soma and Dipankar, there is a person called Ranju Mujumdar, another
Yes.
person Sonali Mujumdar.
Yes. Now, my lord, three persons are relinquished, my lord. The petition number 1 and 2 and 3. 4 is not there, my lord. So that is why I have to come here, three persons only.
Who is not there? Soma, Dipankar is not there.
Dipankar is not there. Dipankar is not the person against in whom whichever the relinquishment is there. So 3 persons are there. So when court finds, my lord, that they can be represented by the
So see, the discussion of the court is on the right to sue service under order 22.
yes, order 22 may not be my lord, applicable.
How do you find fault with this?
No, but my only submission, my lord, that order when court we have filed a petition under 151 also. My lord, order 1 rule 10 has not been mentioned. It may be.
Order 151, can you just invoke it?
No.
When there is a specific provision in
No,
law?
state provision, my lord, court can, but if your lordship see order 1 rule 10(2), court has the,
You invoke order 1 rule 10(2).
my lord, yes, order rule 10(2), my lord.
There is no reflection in the order that we had made an order to.
No, that is not reflected, but it can be, my lord, if your lordship see.
You file another application under order 1 rule 10. You file another application.
But that can be done, my lord. That
We'll
can
say
be-
without prejudice to the observation made in this petition.
Yes.
That has to be considered independently. I think that is serve the interest of justice.
But but the court can so much, my lord, that can.
But there has to be a reflection that was conveyed to the court.
My lord.
Court was considering order 22. But Sri N. Sahevala, Palestinian Council, assisted by Sri N. Sahevala, for the petitioners. The petitioners, who are 3 in numbers, have filed this petition under Article 227 of the Constitution of India, challenging and ordered it 3/7/2020, passed by the learned Muslim number 2, Dubri, entitled to number 420 of 2015. By the state order, a petition made under order 20, rule 2 of the CPC, read with section 151, which was filed by the supported petitioners for substitution of the name in place of the defendant number 3 in the aforesaid title to has been rejected. Error. The senior counsel has submitted that the one that among the 3 petitioners, the petitioner number 1 is the wife of defendant number 3. However, the senior counsel fairly submits that the petitioners numbers 2 and 3 are not immediate relatives, but it is submitted that there is a relinquishment deed.
2 relinquishment deeds.
There are 2 relinquishment deeds by the executors of the power of attorney, namely the defendant numbers 1 and 2, in favor of the defendant number 3.
Petitioners.
No. Power of attorney was
In favor of defendant.
the executor power of attorney.
Yes.
Executors of the power of attorney numbers, executors of the power of attorney by the defendant numbers 1 and 2 in favor of the defendant number 3. And on the strength of such relinquishment deed, the rejection ought not to have been done. It is further submitted that under the provision of
Order 1
order 1 rule 10,
even
the
without
court on its own
either upon or without application of private.
Order one, rule 10 within bracket 2.
10-2.
10-2. The court can even so moto.
Yes.
Add or strike out any parties in the interest of justice. Consider the efforts and submissions made and the impugned order has also been examined. Though the senior counsel appears to be correct in contending that the court would have exercised powers, so motor powers for implement, the discussion in the impugned order appears to be confined to the petition filed under Order 22, Rule 2. And there is no reflection in the order that any contention was made to invoke the powers under Order 1, Rule 10-2. Under those circumstances, this court, in exercise of revision jurisdiction, would not be in a position to find any legal information with the said order. At the same time, the issue of existence of a relinquishment deed in favor of the petitioners without there being any adjudication cannot be foreclosed at this stage. In view of the above, this court is of the view that interest of justice should be served and the balance of and the equity should be balanced if equities are required to be balanced. Therefore, while dismissing the present petition in absence of any grounds made out for such interference, the petitioners are at liberty to file appropriate application under Order 1, Rule 10-2 for implement of parties. And in the event of such application being filed, the same would be some is directed to considered in its own merit and without being influenced by the earlier order of dismissal dated 3/7/2023, wherein, admitted only the application under Order 23 was the subject matter of consideration. Petition according to the disclosure. This is a Chakraborty. What matter? And Mr. Usamian, some urgent, extreme urgent, what was there?
My matter is Lordship. Lordship, here arbitrator has been appointed, Lordship. Was herself was the secretary of the main arbitrator who has expired. Moreover, she has been appearing for the MES Builders Associations. That's it, and this arbitration is against the MES. That's why we filed a petition before, but she is proceeding. She wants to, arbitrator wants to proceed with the proceeding, Lordship.
We have not understood. You filed a review application.
Review application. But judgment was by, the order was by Justice Koteshwar Singh.
Doesn't matter. What has happened?
Lordship, here opinion, Lordship, initially, late Colonel Manoranjan Goswami was appointed as the arbitrator.
Okay.
And he expired, he could not complete them.
Okay.
Yes, now the present arbitrator was the secretary of that arbitration tribunal.
So
What is your difficulty?
now difficulty is the lordship. She is appearing for MES contractor against us lordship. She is appearing in a case of MES builder associations. And this is relates to the MES lordship. And so she has been passing exorbitant award in the most of the cases.
That's a different matter. See, the present arbitrator was the secretary of the earlier arbitrator who had passed away. Will it be a disqualification?
No, our
What is
objection
your
is,
second objection?
our objection is that she has been appearing in the two cases against the MES lordship.
This is a case of appearance.
Yes, against the MES lordship.
Where is the dispute?
I have stated in the case number, paragraph 6 lordship.
Paragraph
6. And in two of the cases, I am defending the MES lordship in both the writ petition. There are other cases also in which the arbitrator is appearing for the contractors.
Now, what review do you have? Which order are you looking for review?
Lordship. Page 10 lordship.
Yes.
11 is the.
Where is the other side?
Other side, lordship notice should go, lordship.
No, it's a motion matter over.
First time listed
First
for the
time
first time.
But you did not object to.
Lordship, in fact, lordship, yes, they did not receive any notice and all. Just on the very first day it came up and.
Have you filed an objection petition?
Yes, we asked.
Where is the petition?
That has not been, we just made some request communication, lordship.
Now, have you filed some application before the arbitrator? Has the declaration been made that he doesn't have any interest?
No.
That is because that is a. Okay, we'll decide it today, not at the time. When is the next date?
Tomorrow, lordship.
Third three. H. Chakraborty, who by means of this application has paid for review of an order dated 21/12/2022 passed in ISA with number 3374 of 2022. Full stop. It is submitted that the arbitrator, the learned arbitrator who has been appointed by the aforesaid order dated 21/12/2022 has been appearing as a counsel against the present respondent in at least 2 writ petitions, correct?
Lordship.
And therefore, there is an apprehension on the fairness of the procedure to be adopted. Court of para. The allegation would require some deliberation, which cannot be able to be done with this due to paucity of time. Compare. At the same, no, three, Chakraborty, the London Council, however, informs this court that the next date in this proceeding is tomorrow. Considering the peculiar facts and circumstances of that this matter be listed for consideration on Tuesday night. Tuesday night? Lordship. Tuesday night. Tuesday night. Also. However, comma, in the interest of justice and to balance the equity of is directed that further processing in the connected arbitration is it numbered?
Lordship. Only the CA number has been given, Lordship.
Arising out of the order dated 21/12/2022, passed in ISF 57/4 2022. Party company division. MP MS DD Engineering Construction versus Union of India shall remain suspended. The aforesaid order will, however, be reconsidered on the next day. Deeply obliged. The rest, you could give it, Mr. Goswami, anything, if you can help you. What is the
Urgency is not safe. In this particular case, we are from the common ancestor, the family members. There is a entry grade to the antidote Nalbari.
How can Chaudhary and Goswami be from the common place?
Lordship, we are from the common place.
Common place.
Common place.
Okay.
He also knows everything. He also knows. We have
And you have to make amendment of the pleading. We are from the common place. Nalbari.
It's not very Bharatiya Cinema Hall practices owners. Dispute between the brothers.
I do not know.
Common brothers.
Okay, that
Plot has been divided among the brothers. He has the entry to the directly to the his plot, and there is a common road to the other family members. He claimed filed a suit that I should be given the right to the common fund. Trial court originally decreed the suit. Thereafter, we preferred appeal. Appeal judgment set aside and remanded the matter with a fresh issue. Thereafter, again suit has been decreed. Thereafter, settlement has been arrived at that we will allow him to use this road also. We have no objection to that effect now also. We have no objection to that effect that we will use the common fund. Now, Lordship, the trial court has decreed in the suit itself, he has stated there is a common gate and we install a key in the gate. That is why there is an obstruction in the gate. He cannot enter. We prayed that the gate should be there, but key will be with both of us. He will also use the key. We will also use the key. And when we enter at the night, we will close the gate. Now, Lordship, there is a decree not to put hindrance and right to use the gate, right to use the path, not to remove the gate. Executing court demolish all the gate. That is why, Lordship, our compound is free. Now theft is occurring day by day. We have engaged to, Lordship, the Sokidar cycle also removed by the theft. Now we
not removed.
Sokidar removed.
He's still there.
Still there. Night Sokidar, Lordship. Now I want only one protection, Lordship. Let be the gate there and key will be both of us. Both of us will use the both of us will use the gate.
My difficulty is that today only I have come to know about his suggestion. I don't have any instruction at this stage.
Okay.
Temporary measure, Lordship.
Take instructions. We'll have it on Monday or Tuesday.
Yes, that is fine.
Temporary measure, some
3-4 days you don't sleep at night.
The problem is that gate is not there. If the gate would have been there, then there would have there would not be any difficulty.
Now to construct the gate, you need some time. You cannot construct the gate in one day. Fabrication.
Gate is already there, Lordship. Gate has been already removed.
No,
No, it's
It has been removed now. I will to,
Removed by the Nazir, it's executing court's order.
if you have some settlement between you, well and good.
We'll talk-
Otherwise,
We'll talk to them.
otherwise, with the judgment, there is no order that gate should be removed. He has specifically said in the plane, there is a gate, we have installed a key indicate. That had, the right has been declared, we are ready to
Okay, we'll have it on Monday.
Right.
Monday is okay for you?
Monday.
Third, three, S.K. Goswami, Learned Counsel for the petition, who has expressed urgency in the matter as due to the impugned order, the petitioners are facing grave hardship on a day-to-day basis. Preempt to the Learned Counsel has entered appearance for the respondent number.
Full response.
Sole response.
Sole respondent.
We are for the all brothers, he is alone.
He is the youngest. Youngest.
Youngest. brother.
Not youngest, he is uncle. We are the brother's son, he is the uncle.
Oh, okay. Has entered appearance and has submitted that he may be given some time to obtain instruction. Considering the above, that is matter listed on
Monday looks.
or
Or Friday looks, if possible.
Friday will be too hard. Let it be on 7th. 7th, come up with instruction and try to convince your client.
Hello.
We do not anything, Lordship. He will be with him. If he installed the gate.
But if you change the lock at the night,
No, Lordship. He will, that will be in front of the court, Lordship.
you put another lock
That
and
will be
give
in front of the
another
court.
key. He's trying to open, he's not opening.
Again, there will be dispute.
Lordship, decree is not to remove the gate. Lordship, will see.
And who will close the gate, that will be another issue.
Oblige, sir.
I'm a pleasure.
Okay, rest days to be good. It also might put a bit of a area. Huh? Mr. Chakraborty, you try to have your order. Where is it?